Right. Welcome again, and thank you for joining us for wherever you are, morning, afternoon, evening. Welcome to this 12th session of the Legal Symposium from the Dutch region of AIIC. It's a pleasure to have you. Today we're going to look into the dynamics of universal jurisdiction. And as we usually do, we've organized this as a training session. This should be seen as a big brainstorming session for interpreters. So I really encourage everyone to ask as many questions as possible. There are no silly questions at all. If you'd like to tweet, please use this hashtag. And please don't hesitate. I need to remind you of the GDPR rules. There's a disclaimer that you saw on our invitation when you registered on the AIIC website. And I think it's going to be displayed in just a minute. There it is. So if you do not want your picture to appear on screen, or if you do not want your name to appear, do not turn on your camera, rename yourself on Zoom, and please ask questions on Slido anonymously. We'll have two sessions, and in the middle, we'll have a short break of 15 minutes. After the two speakers in the first session, we'll have a Q&A session. So please feel free to ask questions on Slido and upvote those that you feel should be asked first. You will also have the opportunity to ask questions live, and please ask for the floor by turning on the small hand icon. I also want to remind you that we have interpreters. We have sign language interpreters, and I wish to thank Jeremy and Laurie, who will interpret in American Sign Language. Please be mindful of interpreters, all speakers, right? Speak clearly and ask until you get the floor to start speaking. What else do I need to tell you? You have the Slido credentials here. And yes, after the meeting, we will meet, for those of you who still have energy to do so, on WonderMe, not on Kumo Space, but on WonderMe. And you will see instructions in the chat to tell you how to get there. This is just going to be an informal gathering if you feel like joining us, because usually after a legal symposium, we have drinks, and it's nice to have a chat with colleagues. But this time, this meeting is virtual, I'm afraid. I hope next time will be face-to-face. So the session is recorded. That's an important announcement to make. And this is also the reason why, if you do not wish to be shown or your name to be seen, please do not show your camera, do not show yourself on camera, and rename yourself. You can also turn to our technician for any questions, particularly regarding interpretation. For sign language users, you see an announcement being made right now from our technician, and we count on your indulgence because we are not professional organizers, we are conference interpreters, and this is our very first meeting on Zoom. Ours, not the first meeting as such, but our first legal symposium. I think I'm about done with the housekeeping matters. Now on to our topic. We know that there are times in history that, well, due to a combination of factors, there is an acceleration that takes place. And when it comes to international criminal law, Nuremberg was such a moment. And it seems that the Syrian conflict is another important milestone is in international criminal law. So this is why we find the topic of universal jurisdiction so fascinating. Of course, there are other components and other factors that come into play. But the Syrian conflict is what is really making the use of the universal jurisdiction principle used on such a large scale. Now, without further ado, I'd like to give the floor to our first speaker, and I'd like to thank all of the speakers who have agreed to speak during this symposium. So we're going to hear from Hugo Relva, who is a legal advisor at Amnesty International, and he's going to first tell us what universal jurisdiction is, how it works, where it comes from. Over to you, Hugo. Thank you.
Thank you very much, Sylvie, and good morning all. I'm Hugo Relva. As Sylvie said, I'm legal advisor at Amnesty International for over 17 years, but a very old member of the Argentine section of Amnesty International. I'm based at home, as you can see, and I am in Argentina. And I already had my breakfast, so I am in full conditions to share with you some thoughts. Okay, I would like to share my presentation. Please give me a second. Okay. Sorry, I'm just a humble lawyer. Here it is. What I would like to share with you it's a basic explanation about this concept, very well known, of universal jurisdiction. So the question is, what is universal jurisdiction and why universal jurisdiction is important in the fight against impunity for crimes under international law and human rights violations? First of all, I would like to begin with a very simple explanation. What is jurisdiction? A very simple concept. Jurisdiction, for the purposes of what I'm going to say, in broad sense, is simply the legitimate legal authority of an institution to decide legal questions. So who has jurisdiction on an issue? The person or the body who has the power to decide an issue, to decide in terms of law, of course, legal questions. And therefore, you can easily deduct that judicial jurisdiction is the power of a state's courts to try cases. As simple as that. So jurisdiction is the power to decide something, and judicial jurisdiction, of course, the power of a court in a country to decide a legal matter. The first important substantive issue I want to share with you all is what is known as the 5 principles, the 5 main sources of jurisdiction in all states. All states in the world exercise, all of them without any exception, territorial jurisdiction. What does that mean? That if a person commits, for example, an offense in Buenos Aires, in Argentina, national courts in my country had the ability and the duty to exercise jurisdiction. Why? Because the crime was committed in our country. So that is called territorial jurisdiction. It's very simple. And then there is a space between the bullet points, as you can see. Territorial jurisdiction, which includes on board of a ship or aircraft registered in that state, for example, an airplane flying over the Atlantic Ocean, so an offense is committed there, robbery, for example, something like that. So which state at first has jurisdiction? The state in which the airplane is registered, and this is considered territorial jurisdiction. Then there are 4 main extraterritorial jurisdictional bases. There are more than 4, but these are the main ones. What we call in law active personality jurisdiction, that is, for example, imagine that a state provides in its national law that whenever a national commits a crime abroad, that state will have jurisdiction. Why? Because a national committed a crime abroad. This is called active personality. The contrary of that is passive personality, when a national is a victim of a crime abroad. But this as a jurisdictional basis is really rare. It is provided in several human rights treaties, but always as an option. Then we have what is called protective jurisdiction, compétence réelle. For example, the counterfeiting of currency or seals or other instruments, all related to national security, to secret services, etc. When the national interests of states are harmed abroad, if the state decides to exercise jurisdiction on that case, that is called protective jurisdiction. And the last one, and perhaps the most important in terms of fighting impunity, is universal jurisdiction, which I will explain in detail, and a related concept that goes hand by hand, audedere aut judicare, the obligation to try or extradite, that we will see very soon. So only one territorial jurisdictional basis, and then 4 extraterritorial jurisdictional bases or sources. Well, what is universal jurisdiction? In an old paper that my organization published many years ago, we defined universal jurisdiction in a way that was even accepted by the International Law Commission as a provisional definition of universal jurisdiction in one of its works. Universal jurisdiction is the ability, the power, the faculty of the court of any state to try persons for crimes committed outside its territory, which are not linked to the state by the nationality of the suspect or the victims, or by harm to the state's own national interest. You can see in bold the expression which are not linked to the state, which are not, that's the key aspect of universal jurisdiction. I told you, when the crime is committed in the territory, when the crime is committed by a national, against a national, but in this case, we have that there is no link to the state. That's the essence of universal jurisdiction. A state decides to exercise jurisdiction at first on a case, on a crime, without any connection at all with that crime. For example, perhaps you remember the Pinochet case in Madrid. Well, Judge Garzón, an investigating judge in Madrid, decided to exercise jurisdiction based on a very, very old provision in Spanish law for crimes committed in Chile by Chileans against Chileans. There were no connection at all with Spain at first. So this is a prototypical example of universal jurisdiction, the exercise of jurisdiction, not because one of our nationals has been the victim of a crime abroad, not because a national committed a crime, not because our national interest as a state has been harmed. There is no connection. Again, I repeat, this is the essence of universal jurisdiction. Then, not very orthodox distinction in terms of universal jurisdiction, but some people distinguish, and I think it's important, what is called pure universal jurisdiction to custodial universal jurisdiction. Pure universal jurisdiction is the example I gave of Augusto Pinochet in Madrid and Judge Garzón. There were no connection at all. Some states, and the examples are the former law of Belgium and Spain that were abrogated, and currently, as far as I'm aware, 2 examples are the national law of my country, Argentina, and Panama. Custodial universal jurisdiction is an example of universal jurisdiction, but it's a case in where the state decides to exercise universal jurisdiction only when the alleged perpetrator is in any territory subject to its jurisdiction. In the case of General Pinochet in Madrid, if that case were, this is an hypothetical case, a custodial universal jurisdiction case, Augusto Pinochet should have been under Spanish soil to be tried on basis of universal jurisdiction. So pure without any connection whatsoever, and custodial when the state decides to exercise jurisdiction when the person is in any territory under its jurisdiction. Let me put you a specific, a particular example. In 2002, South Africa decided to enact legislation implementing the Rome Statute of the International Criminal Court. As you know, the Rome Statute of the International Criminal Court makes genocide, crimes against humanity, and war crimes criminal under the statute. So South Africa, as many other states, decided to implement it into domestic law. And I'm transcribing, and you can read, the provision on extraterritorial jurisdiction in this Act number 27 of 2002, which reads as follows. There is another provision, a separate provision on territoriality, which I'm not showing to you, but the one about extraterritoriality says, 3, a person is deemed to have committed that crime, that is to say, genocide, crimes against humanity, or war crimes in the territory of the Republic if that person is a South African citizen, or that person is not a South African citizen, but is ordinarily resident in the Republic. This is the active personality, because it is a South African, or even though it's not a South African national, it resides in South Africa. And letter C, which is the example of universal jurisdiction, that person, after the commission of the crime, is present in the territory of the Republic. That person, there is no specification about the nationality of any person, after the commission of the crime, is present in the territory of the Republic. So this is an example of custodial universal jurisdiction. And in fact, South Africa has exercised and is exercising universal jurisdiction today. And the last example, that person has committed the said crime against a South African citizen or against a person who is ordinarily resident in the Republic. You can see the passive personality principle. Active personality, A and B, universal jurisdiction, C and D, passive personality. When I show you the slide on the 5 principles, I said, remember, universal jurisdiction and a related concept, audedere audjudicare, the obligation to try or extradite. This is the most frequent way that states exercise today universal jurisdiction. This provision that we are going to read is included in a number, I would say 100 conventions: the Torture Convention, the Enforced Disappearance Convention, the Geneva Conventions of 1949 and its first protocol, the Hostage-Taking Convention, in a number of them. What is extradite or prosecute rule? Under the related audedere audjudicare rule, a state is required either to exercise jurisdiction over a person suspected of certain categories of crimes, or to extradite the person to a state able and willing to do so, or to surrender that person to an international criminal court with jurisdiction over the suspect and the crime. I know this definition is rather complex. I try to be more clear with the following slide. It's Article 7.1 of the Convention Against Torture, a convention that has been widely ratified by states, which provides in Article 7.1, the state party in the territory under whose jurisdiction a person alleged to have committed any offense referred to in Article 4, that is to say, torture, is found, shall, if it does not extradite him, submit the case to its competent authorities for the purposes of prosecution. This provision, which I said is repeated in a number of conventions, then provides that whenever states know that a person suspected of certain categories of crime is under any territory subject to its jurisdiction, it's obliged to exercise its own national jurisdiction, unless that state decides to extradite that person to another state. The only one thing that the state is not allowed to do is to do nothing. I repeat, if a state knows that a person suspected, for example, in this case of torture, is under its jurisdiction, it's obliged to bring that person before a court or before a prosecutor to initiate an investigation, a criminal investigation. Unless the state decides to extradite that person to another state or surrender him or her to an international criminal court. So, as you can see, sometimes when a state discovers that somebody is in its territory and is allegedly suspected of responsibility for a crime, this could amount to a case of universal jurisdiction, because that perpetrator, that's a person suspected of a crime, could have committed the crime abroad against foreigners. So there is no relationship with the state, bar the fact that that person is now in the territory of that state. I would like now to share with you a very important decision of the International Court of Justice, the court of the UN system, in the case Belgium versus Senegal, the questions relating to the obligation to prosecute of extradited 2012. And in the paragraph 95, the court reached a very important conclusion that we, NGOs, that we, Amnesty International, take advantage of very often in our letters to governments or in advocacy with governmental delegates. It reads as follows. It follows that the choice between extradition or submission for prosecution pursuant to the convention does not mean that the two alternatives are to be given the same weight. Extradition is an option offered to the state by the convention, whereas prosecution is an international obligation under the convention, the violation of which is a wrongful act engaging the responsibility of the state. Of course, this rule could be applied to all those conventions which contain a very similar provision. And I repeat, and I insist, so what the International Court of Justice have said is that the obligation, whenever a state knows that an alleged perpetrator of a crime is present in its territory, it's obliged under international law to bring that person before the courts for the purposes of a criminal investigation, unless the states decide to extradite that person to another state. More in terms of the judicial practice, I selected two very brief excerpts from two important judicial decisions. One of 1961, the District Court of Jerusalem in the Eichmann case, in which the court found that the jurisdiction to try crimes under international law is universal, full stop. The jurisdiction to try crimes under international law is universal. And when I say crimes under international law, I'm making reference to genocide, crimes against humanity, war crimes, torture, enforced disappearance, and extrajudicial executions. Several years later, the ICTY, the International Criminal Tribunal for the former Yugoslavia, in the Blasic case in 1997, said that national courts of states of the former Yugoslavia, like the courts of any state, are under a customary law obligation to try or extradite persons who have allegedly committed grave breaches of international humanitarian law. Grave breaches of international humanitarian law, it means war crimes, the most severe, the most serious war crimes. So through these two examples, I'm showing you how in the 60s, the District Court of Jerusalem, the Israeli courts concluded that the jurisdiction to try crimes under international law is universal, and how an international criminal court many years later says, recall the obligation based on customary international law for all states, to try or extradite those responsible for war crimes. Then in this slide, we will see, I don't want to spend much time on the history of universal jurisdiction, just suffice to say that in the Middle Ages, this plaintiff of, if the expression is valid, of national laws, making piracy criminal under national law. And I selected one example of a law, of an act adopted by the English Parliament in 1698. Then it's plenty of many examples, particularly in the Americas in the 19th century, of different conventions that made piracy and slave trade criminal under international law. Then we have the 1949 Geneva Convention, the 4 conventions of Geneva on war crimes, and the 1977 First Protocol, which provides for universal jurisdiction for war crimes. The 1973 Apartheid Convention, making apartheid a crime subject to universal jurisdiction, and the same regarding the 1979 Convention against the taking of hostages, the 1982 Convention on the Law of the Sea, which is not, of course, a human rights convention, on piracy again, and the 1984 Torture Convention, and the last one I'm aware of, the 2006 Enforced Disappearance Convention. Some of the examples, I'm not going into the details, provide for universal jurisdiction, and some other ones, as the Torture Convention, the Hostage-Taking Convention, and the Enforced Disappearance, provide for this other related concept of audedere, audjudicare, which very often imply universal jurisdiction, as I said. I have a query for you, and of course I have the answer, which is the following, and is the key question on universal jurisdiction for all states. In the event that more than one state claim priority to investigate and prosecute a suspect for the same conduct, which state should have priority? So, in the case of a competition between states to try an alleged perpetrator, which is the state which has priority to try the case? And I would like to hear in the questions segment different views, if any. But for my organization, as we said many years ago, this is the answer. The state with custody, that is to say, the state who has apprehended a person, who has detained a person seeking to exercise universal jurisdiction, would normally have a better claim than the territorial state to act on behalf of the international community. And this is key, since the presence of the suspect outside the territorial state creates a presumption that the authorities of the territorial state are not acting with due diligence to investigate and prosecute. And finally, the failure to transmit an extradition request would be compelling evidence, in our view, that the territorial state was not serious. Think about the Pinochet case, when Chile claimed that it has jurisdiction to try Augusto Pinochet. So what we said, we were a sort of partie civile in the UK case on Pinochet. that there were not even an extradition request issued by a judicial authority in Chile against Senator Pinochet. So that shows that the claim of Chile at that time was not serious. So in our view, in the view of Amnesty International, those the state who has apprehended, who has detained an alleged perpetrator has a better case to try him or her. But this is a very complex and unresolved question in international law, since, as far as I'm aware, there is no provision which, fix the problem. Sylvie, I don't know how with the time.
Well, if you're done in the next 2 minutes, that'd be great.
Oh, 2 minutes.
If
okay.
That's fine by you.
Sure. Very briefly, without entering into details, the main obstacles for exercising, I forget the word, universal jurisdiction, but it's also valid for jurisdiction in general, is, first of all, the lack of political will. And I'm saying that, as a lawyer, even the best, legal system, the most beautiful laws are useless if there is a lack of political will. And this is the main obstacle for bringing perpetrators to justice, the lack of political will. Then in the civil law system, statutory limitations, because after some time, all crimes, are subject to statutory limitations. So there is no way to investigate or prosecute. The question of immunities, which normally is predicated of some state agents, and the questions of amnesties and pardons. So those are the main obstacles. The final reflection that I would like to share with you, just to show you, because perhaps you will be translators or interpreters in the future in the events related to these two draft conventions. The draft convention on prevention and punishment of crimes against humanity, which is a text adopted by the International Law Commission in 2019, which makes crimes against humanity criminal under international law, and which is today before the Sixth Committee of the General Assembly. And the final bullet point, the draft convention on mutual legal assistance on genocide, crimes against humanity, and war crimes, and strictly speaking on other crimes too, which is an initiative by the Netherlands, Belgium, Slovenia, Argentina, and Mongolia, which is very likely to be adopted next year. These two conventions contain a very good provision on audere aut judicaris in terms of an obligation. So in the future, if those two texts are adopted by the states, all state parties to those instruments will be obliged to exercise universal jurisdiction. Well, that's all. Thank you very much for your patience.
Thank you so much, Hugo. That was extremely interesting. I mean, I learned a lot. I was not aware of this principle. So there is an obligation to take action under international criminal law. And so you have to either prosecute or surrender. But I'm sure we'll get back to this during the Q&A. I was not aware about the two draft conventions you mentioned. So it goes to show that the law is a very rich field that keeps evolving. A lot of non-legal experts have this preconceived idea, at least I had it before I got interested in it, that it was very rigid and that it was not very flexible. But it's not. I mean, you can, it's very creative. But again, we'll hear about the other speakers and from your questions in the Q&A. Now, I'm going to turn to Elies van Sliedregt. Thank you for being with us, Elies. You're a professor of law at the University of Leeds and the director of its Center of Criminal Justice Studies. So with you, we're going to get into the legal nuts and bolts, as it were, of how a universal jurisdiction works. And I think you're going to discuss the interaction between national and international laws. Over to you. Thank you very much.
Thank you very much, Sylvie, for the introduction. And thank you, Hugo, for that excellent introduction to universal jurisdiction, which is very informative and which really leads on nicely to what I want to talk about today. I'll be focusing mainly on the interaction, indeed, of the national legal framework and the international legal framework. And I will start out by talking a little bit about legal pluralism, about the sort of context in which these trials take place. And then I go on to talk about one particular universal jurisdiction case in the Netherlands, where the issues that I raise in that first part, I think, become clearer to you, because universal jurisdiction, the exercise of it by judges in practice, comes with some very concrete, practical questions. And it's, I think, very informative for you to understand that. So yes, after 2 decades of setting up international courts and tribunals, the enforcement of international criminal law is really now up to national courts. The complementarity principle of the ICC is assigning this role as international law enforcer to national courts, which is probably a good thing. It really is the future of international criminal justice. We can't continue to set up ad hoc tribunals. They are costly. In current political climate, there's not a lot of support for it. The ICC really is already struggling. And as I said, the whole system of the ICC is around really bringing on national courts to deal with these crimes. There is increasingly a uniform body of international criminal law at the international level. Initially, when the ICC was set up, there was a bit of a feeling that it wanted to go its own way, that it had its own statute to deal with and didn't really want to bring in the case law of the other tribunals, the Yugoslav tribunal, for example. But now there is definitely this sense that there's actually, it will really help and assist national courts to have a coherent international body of law. So interpreting their own norms of the ICC statute through looking at the ICTY case law is very important, because if national judges want to apply international law, they need to know which law. And the ICC, being the only one in town, is really, I think, the institution that has the responsibility to work towards that uniform body. But we cannot avoid that the field is very much pluralist. By leaving it up to national courts to enforce international criminal justice, you accept that there is diversity, because every legal system has its own norms, and it's maybe there is a coherence around international crime definitions, but there is still also diversity with regard to general principles of criminal law. And that's around, for example, criminal responsibility, concepts of intent, defenses under criminal law. They can really differ per system. So there are going to be differences nevertheless. And there's a lot of work done on trying to make it more uniform, the law, through the Legal Tools project of an NGO, and through the ICC's outreach, positive complementarity. But we are not going to completely avoid this pluralist picture. Now, the domestic judge sits in that context of legal pluralism, and sitting as an international judge in enforcing, for example, the ICC statute when prosecuting crimes committed by Syrians in Syria, there are different ways and different approaches that can take. So first of all, it can adopt an internationalist approach, what I call internationalist approach. And that means that there is authority of international jurisprudence that is prioritized over national criminal law. So with regard to the international crime definitions, but also with regard to the criminal law principles, with intent, with defenses, everything is sort of looked at as the international law prevails by rejecting the own national criminal code. So for example, I think in a particular Canadian universal jurisdiction case, there was a prosecution of a Rwandan where the court prosecuted not just the international crime of genocide, but also the concept of complicity of genocide, which deviated from the national concept. Now, very concretely, there can be differences here. So looking at my own legal system, if a Dutch judge would apply the ICC statute with regard to aiding and abetting crimes, it would adopt a very narrow standard, because you have to prove that the accomplice furthered the crimes, contributed to the crimes with the purpose of furthering that criminal activity. Whereas under Dutch criminal law, there's a much broader concept of furthering or contributing to crimes with a foresight that the crime might materialize, and you accept that risk. So that's much broader than the purpose requirement of the ICC. So there you can see it's a real difference between an acquittal and a conviction, and I will discuss one case where that played a role. So that's one approach. You can take a full-on internationalist approach because you feel as an international law enforcer, that's what you have to do. The complete opposite is the national approach. So you just apply common criminal law to a genocide case. For example, you prosecute for multiple murder and you apply all the provisions in your code, ignoring basically the framework of the international courts, etc., and their case law. And then there is an approach that's sort of a mixed approach in between, where international law is applied with regard to the crime definitions and with regard to particular international constructs such as command responsibility, which is this theory of criminal liability that really has an international pedigree. And then you apply national criminal law with regard to modes of liability, intent, all those general principles. Now, of course, many states, and certainly the ICC states parties, will have incorporated the ICC statute within their own domestic system, and many will have just copied the crime definitions, and some have also copied the modes of liability. But the majority of, as I understand it, is domestic legislation incorporating the ICC statute really only does that with regard to the crime definitions and leaves everything around the general principles up to judges to apply the national law. So this interaction between national and international, let me illustrate this by discussing the Van Anraat case. And I have to then, yes, next slide. So the Dutch businessman, Frans van Anraat, as it was not a universal jurisdiction case, but an international crimes case, he was prosecuted in the Netherlands for having supplied chemicals to Saddam Hussein's regime, and these chemicals were then deployed by Saddam Hussein in the massacre against the Kurdish population in the village of Halabja in the war against Iran. And he was prosecuted for complicity in genocide and complicity in war crimes. The district court acquitted him of the complicity in genocide charges. The acquittal was based on the finding that Van Anraat had no positive knowledge of the intent of Saddam Hussein, of the genocidal intent of Saddam Hussein. Now, this positive knowledge standard derived from the Yugoslav Tribunal and its case law. And it deviates from a much broader standard in Dutch law, which is what I already discussed, this foresight test, or dolus eventualis, to be very technical. And that foresight test would have been much easier to prove, because all you have to show is that he was aware of that there's a risk of genocidal intent and of deploying weapons with that intent, and that he agreed with that nevertheless and continued to supply the regime with those chemicals. So on that strict test, he was acquitted, and then he was convicted for complicity in war crimes. The district court's use of this international standard of the Yugoslav Tribunal with regard to genocide, but not with regard to war crimes, was based on the following reasoning: that genocide as a crime, as an international crime, would have been watered down if a national standard would have been used, if this broader foresight type test would have been used. And that's why the court felt that it had to rely on that positive knowledge test. On appeal, the judges endorsed the conviction for war crimes and the acquittal for complicity in genocide. The court held that even with the most lenient standard of intent, it could not be determined that Van Anraat was an accomplice in genocide. And then as a sort of an extra observation, an obiter dictum, as we call it, the appeals judges said, but this acquittal for genocide, we do this for different reasons, because we do think it's wrong that the district courts prioritize international standards with regard to intent over ordinary Dutch criminal law. And they said, and this is important, when the AIIC statute was incorporated in the Netherlands, the legislator made very clear that it is only with regard to these typical international constructs, definitions of crimes, command responsibility, that international law had to be prioritized and applied, but with the rest, it's Dutch law. And they added, and this is interesting, that international criminal law is still in a stage of development and does not seem to have crystallized completely with regard to all these theories of liability. So let's not go there. It actually increases the uncertainty for defendants. I think following international crimes prosecution at the domestic level, this mixed approach that I just explained is accepted widely. More and more states are going down that road. It does mean that judges at the domestic level would have to, be trained in international law, because they do need to know what's happening and need to understand the jurisprudence and the AIIC statute, etc. But that seems to be the way forward, at least as I see it. And I think this is a good approach. There are many reasons, I think, to leave room for couleur locale. I think international law accepts that also with regard to the hybrid tribunals, the tribunal for the Sierra Leone, the conflict in Sierra Leone, and the one in Cambodia. There was also the mix of international law and domestic law. And as I just indicated, international criminal law is not always very clear at the international level. It's not fully crystallized, or it comes with political compromises. Some of these provisions are very, in the AIIC statute, are very difficult really actually to explain and understand without understanding that there was a real conflict between like-minded countries supporting the AIIC and those against it, critical of it. And also a third reason why it's good to have this mixed approach is it does avoid you creating a two-tier system within your own domestic jurisdiction. So we have to try at least to keep that system as coherent as possible. Okay, so having dealt with pluralism, I'm now going to move on to universal jurisdiction. Keep an eye on the time, Sylvie, don't worry. So this mixed approach that I just explained, where you apply both from both legal systems and you borrow norms from both. When you look at universal jurisdiction, that actually new light is shed on that approach. And I can illustrate this by discussing the case of the Ethiopian, or former Ethiopian, because he acquired Dutch nationality eventually, Mr. Alemo. And he was prosecuted in the Netherlands for crimes committed in the 1970s, the so-called Red Terror purges. He was a member of the military in Ethiopia, and as part of that unit, he was engaged in armed conflict and committed war crimes and crimes against humanity. He was prosecuted in the Netherlands, a country he fled to in the 1990s. The court is not very clear on which type of jurisdiction it actually exercises, because it could also be the active nationality principle, because he now had the Dutch nationality. But reading through the judgment, there's a lot of reference to universal jurisdiction and the universal nature of these crimes, trying to justify why the court has jurisdiction. So it seems to me it's actually a UJ case, a universal jurisdiction case. So let's just assume that and move on from there. He was charged on the basis of command responsibility for committing these crimes as a commander and not stopping them, and on the basis of co-perpetration. They were jointly perpetrating these crimes with others. And we see here the mixed approach. So with regard to joint perpetration, the court applied Dutch law. With regard to command responsibility, it applied international law. The question was raised by the defense here, and also by some scholars: can you actually apply domestic law when you derive jurisdiction from an international title? Remember, Alemo is Ethiopian, or at least at the time. This van Andernaert was Dutch. It's different in that sense. Do you violate sovereignty of Ethiopia when you apply Dutch law? And then secondly, which is another question, which I will address at the very end very briefly, to what extent is the principle of legality an obstacle to applying law of the forum state, the Netherlands, against a person who was not a national of that state at the time of the offences? So let me start with that first question, which really is a question about legitimacy. What justifies courts applying and imposing a certain legal framework, their own legal framework, over that of another state's national? And there's a number of theories that are raised in this context. First of all, the so-called relationship theory, which is the theory where you regard the court as acting as a representative of the international community. So the Netherlands, the Dutch court, would not incur the sovereignty of Ethiopia because Ethiopia, as member of the international community, is also served, its interests are also served by the Dutch trying one of their nationals for international crimes. And in performing that role, the court can apply international norms. An internationalist approach would apply. The second approach would be the caretaker position, where you would say, well, the court is basically stepping into a void left by another state, the state's national, Ethiopia. And as such, it should actually apply Ethiopian law. And this is something what you see in private international law, where disputes are solved, for example, an international company registered in state B, but tried by state A, that state A then applies the law of state B. That's a sort of what they do in these disputes. You could extend this as an analogy to international criminal law. I personally am not a fan of this theory. Anyway. And then thirdly, there's the so-called reason dependence of standing theory. This sounds very complicated, but it's actually really simple. It was proposed by Reeves. And what he says is the simple fact that a court has standing, and that means that it has the ability to try to address international crimes by conducting fair trials and granting adequate safeguards, etc. That's sufficient. So that is sufficient for a court to do that. That's why it is legitimate. If it can uphold the rule of law and conduct a fair trial, that's fine, that's sufficient. And then it can just apply its own law. I won't go into a lengthy debate of these positions, but it's just to give you some thoughts around the legitimacy of these courts exercising universal jurisdiction. I personally think the third theory is the most attractive one, simply because the other two are a bit vague and unclear. I don't think international community, it's an elusive concept, to be absolutely honest. The caretaker position, one court stepping in, as it were, into a void where another state leaves because another state is not taking up its responsibility, is not attractive. When you talk about universal jurisdiction, it is really universal. It's not a bilateral situation, right? But it leads me to conclude that from a legitimacy point of view, there's nothing wrong, I think, with domestic courts exercising their own or applying their own law over other nationals when they exercise universal jurisdiction. So that's the reasoning, I think, that can be embraced. Last few thoughts about the legality principle. Some scholars, some of my colleagues have proposed that this is a problem in this particular case, that you apply Dutch law to a person who was an Ethiopian. He was Ethiopian at the time. He had no accessibility to Dutch norms, and therefore it wasn't foreseeable that that this was going to be a crime, or that this was a crime rather. I disagree with this critique. I think it's very often, the foreseeability argument is very often used as a bit of a smoke screen. There's a lot of critique with regard to expansive extraterritorial jurisdiction, and I think that was raised already by Hugo, these passive nationality principle, where you extend jurisdiction over your nationals as victims. It's quite controversial, because that means that those who commit the crimes against those victims don't always have access to norms. How do they know that that was a crime? But with international crimes, of course, we all know that these are crimes, and I don't think there's a real strong argument in saying that it was not foreseeable to commit these crimes. So in that sense, the principle of legality has always had a bit of a different role when we discuss international crimes. And the other thing I think that you can put forward against this legality objection is that international law itself is not always clear, and certainly those norms around criminal law principles, principles of liability, co-perpetration, which is one of the points that some of my colleagues have raised as a problem. Why apply Dutch law on co-perpetration? Well, I don't think there's a lot of clarity at the international level, and certainly some of the legal experts today will know that the ICC is struggling at the moment in trying to accept or adopt a clear theory on criminal responsibility. They had a case earlier this year, Nataganda, where there were four separate opinions and one dissenting opinions on one legal theory, indirect co-perpetration. So international law does not necessarily come with a lot of clarity. So anyway, until we have a widely accepted statutory framework of international criminal responsibility, we will have to work with what we have, which is a set of rules that in its core is well established, and it goes mainly to the crime definitions, but that there are norms on criminal responsibility that will diversify and be pluralist, because we tend to apply our own domestic models with regard to those concepts. And it's where we are at the moment. Yes, it would be preferred to move towards a more coherent theory at the international level so that we can deal with these cases, you know, domestically as equally as possible. But for the moment, this is where we are, and we have to settle with this. And with that thought, I will leave you. I hope I've not taken too much time. I think I'm quite on time, actually, looking at it. So I look forward to questions and answers. Hopefully we'll persuade you of my arguments. Thank you very much.
Thank you very much, Elies, for this very insightful presentation and for stressing the fact that it's always a question of compromise, right? And that international criminal law is still in the making, and it needs to continue developing and to crystallize eventually. But a good question is whether this will ever happen. I was also very comforted to hear that judges, national judges too, need to have a better understanding of the ICC statute, and that things are not always crystal clear. That's quite reassuring for us as non-legal experts. And I also quite like the distinction you made between a case prosecuted under as an international crime, like in the case of the Dutch businessman you mentioned who had sold chemicals to Saddam Hussein, and a case brought under universal jurisdiction. Because I must say that for me, at least, it's, yeah, I tend to confuse the two, because there's the notion, of international and then of universal, and the two are not exactly the same. I don't want to continue speaking. I'm now going to open the floor for questions. Should I give the floor to Jan or Annie for them to guide us through Slido, and then maybe we'll open the floor for you to ask questions directly to the speakers. So over to you, Annie.
Yes, hello to everybody. So I'll take one question on Slido, which is for Elies, I think. The question says, and it's an anonymous question, you say ICL is still in development and has not crystallized yet. Do you mean ICL is developed through case law at the ICC? What embodies ICL?
That's a really good question, actually. Yes, I mean, the ICC being the only one in town, I mean, yes, we've got the Kosovo Tribunal, but with all due respect, it's not of the same caliber as the ICC. the ICC is the one institution we'll look to interpret crime definitions, to further the law with regard to certain concepts like command responsibility, typically, you know, international concepts. And the interesting thing is really that the ICC as a statute is quite detailed. And the reason was that those who negotiated the statute and its text did not actually want judges to have that much room for interpretation. States were quite keen to have a very clear document that, you know, would not give way to broadening, because that's what they were afraid of, and incurring on sovereignty. But to everyone's surprise, judges have been very active. And certainly if you look at the principles of criminal responsibility, an article in the statute, Article 25, is really interpreted quite widely, and all sorts of theories have been read into the text. And yet, it's the same you could say about the crimes against humanity definition. It has also led to quite, you know, novel interpretations, and war crimes also recently. So yes, ICL, I think in terms of the future, where it's going to go and develop, and what will be the body of law that domestic judges will take guidance from, it's that body of law, and judges take the space, the room, the discretion to interpret the statute. It's really a living document in that sense.
Thank you for that. I'm going with the next question. This one is for Hugo Relva, and it's the question: in the case of audere aut judicare, does diplomatic immunity of a head of state preclude a state from prosecuting or extraditing the individual in question?
What a good question. What a good question. This is an absolutely key issue today in the international law. I think that I want to be fully honest. My organization disagree, but I think it's a settled principle of international law today, and I repeat, unfortunately, that heads of state, heads of government, Minister of Foreign Affairs, and diplomats enjoy full immunity with regard to any crime, any act committed in its official capacity. Unfortunately, my organization dissents. There is a very well-known case of 2001, if I'm not wrong, the Gerodia case by the International Court of Justice, where recalls this principle. But fortunately, in terms of functional immunities, which is not the question that that was asked to me, there is general agreement, and the International Law Commission seems to be very close to agree on the principle that crimes under international law, that is to say, the state agents in general, aside those that I have mentioned before, are not immune if they commit a crime under international law. Thanks.
May I ask a question, please?
Please do.
If I may, I have another question on universal jurisdiction, which is not universally ratified, says an anonymous question. Why is that? Does that imply any shortcomings?
May I ask a question, please? May I ask a question, please?
I'm okay with you asking a question, Mr. Prokofiev, although I just understand the question was about the universal ratification of UG. It's not university ratification. UG as a universal jurisdiction is a principle that you find in a number of treaties which are widely ratified, and it's generally understood as customary international law. So even without ratification, states have to abide by its effect. So that's, I think, a very quick answer to what you said, Annie, if that's okay, and then we can move on to Mr. Prokofiev.
Yes, if I
I'm
can.
not Mr. Prokofiev. I want to ask a question.
Oh, sorry.
Please go ahead. Sir, I don't know who you are. Please go ahead. Ask your question.
Well, it doesn't matter, but I can give you my name if you want. My question is a generic question. You said that we are being recorded. Will we receive a link, all those who have registered for this webinar, a link to the recording, or will it be on YouTube, please?
The idea is to provide the recording and to put it on the AIIC website for a limited period of time. We haven't decided yet how long, but we may have to do some editing. But yeah, you can have access to the recording after the.
Thank you very much for your
welcome.
kind answer. Thank you.
Sorry, Annie.
Yes. I have several questions here on Slido. Maybe I'll take this one. Judgments also serve to educate the people in the country concerned. So is this role of less value or less important when the trial takes place in another country?
May I, Annie?
Yes, please do. Thank you.
Again, a good question. I think that in an ideal world, it would be perfect if states where the crimes were committed exercise jurisdiction. But based on the worldwide experience of all the genocide, crimes against humanity, and war crimes committed everywhere, states are reluctant, to say the least, on exercising jurisdiction. That is why victims, I'm thinking of the example of victims in my country. They decided to go to Madrid because at that time it was impossible in Buenos Aires to ask courts to exercise jurisdiction because of the amnesty law. So that was why victims, and it's full of examples, go somewhere else to beg to courts to exercise jurisdiction and stop crimes. That's the very one reason for exercising, extraterritorial jurisdiction. But I agree that in an ideal world, if the crimes were to be tried in the state where the crimes were committed, that would be perfect.
Thank you for answering. Mr. Victor Prokofiev. Sorry,
can I
go
just
ahead, please.
add very briefly that, because I think it's a great question, and it's indeed one of those things that national courts are bound to be less visible than international courts, but some countries take this responsibility really seriously. So Finland, for example, has gone to some of the states, I believe in Africa, don't remember which one exactly, where they basically conducted proceedings there to show to victims what is happening and to those that have perpetrated crimes against them. So yes, it's definitely more challenging for domestic courts, but some really do feel this responsibility.
Okay, thank you very much. Sorry, I didn't mean to interrupt your answer. Mr. Victor Prokofiev, you put a question into the chat. Would you like to read that out?
Yes, thank you. My question is with respect to the division of labor, as it were, between international courts and domestic courts. I'm slightly confused in terms of the jurisdiction. Let's say the ICC has handed down a judgment, convicted a perpetrator. What remains for the domestic courts then is to just enforce that judgment, apprehend the person and send the person to prison, or does the domestic court have to retry the matter on the merits? The reason I'm asking is because Eli mentioned that concept, the Dutch concept of foresight, which leads me to start thinking in terms of what is the role of the domestic court? Does it apply its own law again to the same case, or does it just enforce? Thank you very much.
Hugo, do you want to start? You're muted.
Sorry. Once the International Criminal Court has rendered a final decision, that is a final decision for states party to the Rome Statute. But of course, it's not, an obligation to be observed by non-state parties to the Rome Statute. I don't know if that answered the question.
Can I just add to that? A good question again. So no, indeed, it's final, the decision by the International Court, and strictly speaking, that ends the case, and then what's left up, or what's left to international or national courts rather, is maybe if it concerns the same situation, say an armed conflict in the Congo, that they can try other perpetrators that were, involved in that particular conflict, or low-level people. That's very often the thought, that domestic courts deal with the low-level guys, and then the International Criminal Court will deal with the more senior perpetrators. But what you see is actually that because there is no double jeopardy principle that applies across the board internationally, there is nothing stopping a domestic court retrying a person that's been tried by an international court. And we have seen in the case of, I can't remember the name now, one of the defendants, maybe even two at the ICC, that the Congo is now trying to prosecute them again for slightly different charges, but related to the same type of conflict or the same situation. So I think that's problematic, actually. Yeah, there's a whole legal debate around this. So you can have this cascading situation of prosecutions being done again, as it were, and revenge prosecutions, which we see in the former Yugoslavia, for some people who've been acquitted by the Yugoslav tribunal are then prosecuted domestically. So no, ideally speaking, they are separate. So once it's final at international level, that's it. But this is not an ideal world in which we live.
Thank you very much.
Katanga, indeed. Thank you, Natalie. There it
Annie,
was Katanga. Yeah.
Annie, may I say something, please? I'm sorry, I don't want to, I was thinking on something that Elies said minutes ago about Finland as an example. I work as legal advisor for Amnesty, and in my own experience, is this one thing that those states exercising jurisdiction, universal jurisdiction for crimes committed in Latin America, Africa, and other regions, and a different perspective of crimes committed locally. I'm thinking, for example, of the crimes committed in Northern Ireland, which, as far as I understand, not be honestly tried in the UK. On the contrary, the UK is close to enact or has already enacted legislation providing for statutory limitations for the same crimes they said that abroad are not subject to statutory limitations. Canada exercised universal jurisdiction very often in the past, mainly. But what about the crimes committed against indigenous population in Canada? Zero. I don't know about Finland. I know that the role played by Finland today is wonderful, and we fully support that. But what about the crimes committed by Finland nationals during the Second World War? So it is an experience, with all due respect, but I think it's wonderful that the states decide to exercise universal jurisdiction, but it is not the same crimes, the same rule for crimes committed. Think on France, for example, a wonderful role about the crimes committed in Africa. But what about the crimes committed by French forces in Algeria? It's full impunity. So I would be more prudent on this question of, that's wonderful states exercising universal jurisdiction. And I'm saying that from a country where impunity prevailed for many, many years. And this is awful. Sorry.
Thank you. May I say something, Annie? Thank you very much, Hugo. I think that this is interesting, and that there are probably questions in Slido about that. I mean, going to the disadvantages and limitations of the principle of universal jurisdiction, the risk of introducing, as you were pointing out, something that is tantamount to double standards. But maybe we can discuss that also during the next session. Another aspect we will discuss during the second session is that of visibility and making justice visible. This will be the focus of Olga's presentation in the second session. I see that Ezekiel has asked for the floor for a while. Would you like to ask your question now? And then we'll go back to Slido. Thanks.
Yes, thank you. Can you hear me?
Mm-hmm.
Yeah, okay. I have one or two questions for, I think, for Hugo. And my questions are relating to the obligation to prosecute or extradite. I was a little bit confused when trying to assess the basis of this obligation relating to the core international crimes. Because it seems to me that when we look to the 1948 Convention against Genocide, it seems that this obligation does not exist. It seems that it is only a territorial obligation that exists in relation to genocide. And now I was just wondering what maybe now currently is the current state of international, the basis of this obligation. Can we, or are we now able to conclude that this obligation might derive from customary international law? That is the first question. The second question is also relating to the crimes against humanity. I was also confused since I know there is no general convention regarding the crime against humanity. And I know the draft articles, the AIIC draft articles also illustrated that there is this gap under international law, and the aim of the AIIC was to fill that gap. So currently, what do you think may be the basis of this obligation and also the basis of the universal jurisdiction, since for those two major crimes, there is no obligation under the convention? Thank you.
Thanks, Ezekiel. Very good question. You are absolutely right. What you said about the Genocide Convention of 1948, it's true. It only provides for territorial jurisdiction and also says of a potentially international criminal court in the future. So far as I'm aware, the obligation to extradite or prosecute, it's an obligation regarding grave breaches of the Geneva Convention, that is to say the most serious war crimes, not to all crimes, just the most serious, grave breaches, torture, and enforced disappearance. That is why one of the reasons why my organization is advocating for the prompt adoption of a convention on crimes against humanity, because if that convention is adopted by a state, all crimes against humanity, murder, extermination, apartheid, imprisonment, etc., will be subject in the future to the rule of audedere aut judicare, to try or extradite as an obligation under international law. But I have nothing to object to what you have said regarding the limited scope of the obligation today. I agree.
Okay, before we'll continue with the next question, I'd like to put the link to Slido in the chat because some people cannot get onto Slido. Here is the direct link to the questions, or where you can ask questions. Then I'd like to do a question first, which was referred to me in the chat because she was not able to get onto Slido so far. And the question is the immunity of heads of state, etc., limited to their time in office? So if they are not in office anymore, can they be prosecuted for crimes committed during their time in office?
Yes, they can. Yes. Not during the term of office. If you give me a few seconds, I could find the draft article adopted by the AIIC this year on this question. But I remember that an incumbent head of state, head of government, minister of foreign affairs could not be prosecuted while in office. No way whatsoever. There is no way. Even for genocide, unfortunately, as I said before. But once, you know, that person has concluded his or her mandate, could be prosecuted.
I have a controversial question. May I ask it?
Go ahead.
Yes. What about the United States, the UK, and other countries, Western allies who invaded Iraq and killed tens of thousands or even hundreds of thousands of Iraqis? Is that considered a war crime? I presume the answer is the United States and possibly the UK are not party to ICC or whatever. What's the answer?
Should I reflect on that briefly, and then Hugo, you can give the decisive comment on that one. So both the US and the UK have been on the radar of the prosecutor of the ICC, and not so much with regards to killings in armed conflict or in conflict of thousands of people, as you say, but more with regard to the detention and alleged torture. The UK has basically adopted a law which does allow the prosecutor to look into these allegations. Initially, there was a statute or a bill that came with a type of statutory limitation. I won't go into the technical details. It was a presumption against prosecution longer than 5 years ago. And that would have basically led to immunity of UK military for crimes in Afghanistan. And that was very controversial. And then I just want to link back to what Hugo said about, you know, great, all these states doing these universal jurisdiction cases, but it's at the end of the day, it's also selective. And you certainly see that with the UK. They're very keen on prosecuting Rwandan Hutus who fled to the UK and, you know, who could be prosecuted for genocide, but they're very reluctant to prosecute their own people, which is often the case in international criminal law, their own servicemen for crimes in Afghanistan or Iraq even. So the US situation is, I mean, more recently, the new prosecutor of the ICC has said that it will not really look into those crimes, or allegations rather. It's unlikely that there'll be cooperation, especially now that Afghanistan, that, you know, the US has left, etc. So it's a frustrating business. The UK is a member to the ICC, a very prominent one, because of course it's also a permanent member to the Security Council, the Council, the permanent 5, but the US is not. So yeah, that's very briefly some reflection on a very controversial topic.
Thank you for your excellent answer.
May I say that it seems to me that the question is controversial, not just regarding the application of the universal jurisdiction principle. It's also controversial in the existing courts, right? I mean, in the ICC. The ICC is criticized, or was criticized in particular by the United States, for being one-sided. So isn't this the sort of criticism that's unavoidable? What do you think, Elies?
Yes, it's unfortunately a criticism that undermines legitimacy, I think, of the ICC. Although I have to add, I mean, being in this field of international criminal law, politics is so much part of it, and we shouldn't sort of accept that maybe, but it's part of playing the game, as it were, of ICL and conducting international trials. It comes in much more directly compared to domestic criminal justice. And it does undermine the ICC standing. I do think that there is some value to say, well, it will be difficult to actually get the evidence, because if the US is not going to assist, and they won't, and we were, you know, especially under the previous president, we've seen that there was a real reluctance to work with the ICC. In fact, they would ban the prosecutor from traveling there, seize assets, etc., or rather freeze assets. So it's a difficult practical, the real practical difficulties in prosecuting these crimes, but it looks bad because it basically is that the weaker states, they are very much part of the docket of the ICC, and the powerful ones can just escape liability.
Right. Thank you very much, Elies, for your reply. Did Victor want to ask another question? I think his hand was raised again. Victor?
Yes, indeed. Now,
Okay,
if I
please go
may,
ahead. Yes, please do.
coming back for a minute to the question of the immunity of heads of state and government officials, do you think that Nuremberg is a good precedent of former, at least former heads of state and heads of government being brought to justice? Thank you.
Victor, a good question you raised, but I should have said at the beginning that there is on the question of immunity, there should be distinguished two levels of jurisdiction. Before international criminal courts, like the one in Nuremberg, in Tokyo, ICTY, etc., the ICC, there is no immunity for heads of state. The question of immunities that I mentioned before was related of state officials from foreign criminal jurisdiction, that is to say, at the national level. That says, for example, that if a head of state visits another country, that head of state is absolutely immune. There is no way at all to investigate and prosecute that person in a foreign state. A different situation arises when we deal with international criminal courts. The Rome Statute of the International Criminal Court contained an explicit provision, Article 27, where there is no immunity for heads of states, of government, etc., of those state parties to the system. So if a head of state party commits a war crime, the ICC will have jurisdiction. But this is not the case at national level. I don't know if that answers your question.
Absolutely. Thank you very much, Hugo. That's very clear.
Thank you.
Well, thank you very much. I'm looking at the clock and I see that it's 3:30 now. So I suggest that we end the first session now. I wish to thank Hugo and Elies very much for their presentations. We would have many more questions to ask, but maybe there will be other opportunities. So thank you again for coming to speak at our symposium. And if you can stay, Hugo, we'll be happy to keep you for the second session and maybe field more questions later. I know that Elies has to go, but it was a pleasure having you. So we're now going to take a short break, 15 minutes, and we'll be back at 3:45. Thank you very much. See you.
Thanks, Zach.
Hi, everyone. I don't know if everyone is back. We have another minute and a half or so. I hope that you managed to get a cup of coffee or something to eat. And we are about to start the second session. So in another minute or so. Thank you. Right, dear colleagues and dear participants, I think it's time to start our second session now. We've heard a lot about the background and about the legal technicalities on how universal jurisdiction can take place. Let's now try and go into practical cases. I would like to give the floor to Nathalie von Wistinghausen, who is a lawyer with the Berlin Bar. Nathalie will speak in German, and she's going to illustrate how the universal jurisdiction principle is implemented in Germany. And I believe that she's going to discuss two cases in which she was involved. One that has to do with offenses committed in Rwanda in '94. And the first genocide case related to crimes committed by ISIS against the Yazidi. I would kindly ask everyone to please mute themselves. So if your mic is still on, please turn it off. And without further ado, I now give the floor to Nathalie. Dankeschön.
Merci, Sylvie. Ja, ich begrüße Sie aus meiner Wohnung.
Yes, I'd like to welcome you from my home here in Berlin on a wonderfully sunny autumn day, which is, it's quite unusual for me to be talking about universal jurisdiction in German, because the conferences in the majority of cases are carried out in English. And this is new ground as a topic in Germany. So what I would like to tell you about is two criminal cases that I have personally been involved in, and from very different perspectives. One of them was a case with the Higher Regional Court of Frankfurt, and that was where I was representing the accused, a Rwandan mayor, who had come to Germany and had been accused of being involved in the Rwandan genocide. And the second case I'd like to talk to you was also a court before the Higher Regional Court of Frankfurt. And interestingly, exactly before the same panel of judges. There, however, I was representing the joint plaintiff, and this was a Yazidi survivor of the genocide. And the accused was an Iraqi national, a presumed member of IS, who was accused of being part of an international criminal organization, but had also been accused of, among other offenses, being part of a genocide. Now, these are very large, very complex cases, and all I can really hope to do here is give you some insight into it. But perhaps when it comes to the question and answer session, we can delve into greater detail. For starters, perhaps it's interesting to explain why these two cases actually came before German judges, and the reasons are very different in each case. Both of them can be traced back to the principle of universal jurisdiction, but in the Rwandan case, it wasn't purely a matter of universal jurisdiction because the accused was actually living in Germany when he was apprehended. And the Iraqi accused in the second case had actually been extradited to Germany. Mr. Rwabukombe, that is the Rwandan national, who had been accused of genocide, there was a Rwandan international arrest warrant issued against him, and the German judicial authorities decided at the time not to extradite him to Rwanda because he couldn't expect a fair trial in Rwanda. And this is case law, which I perhaps won't talk too much more about today, because in the meantime, other extraditions have taken place to Rwanda. But at the time, that was the position adopted by the German judicial authorities. However, that meant that the federal prosecutor responsible for this case didn't want to be left out as such, and said that if there was a person living in Germany who had been accused of genocide, this had to be tackled, and therefore a German arrest warrant was produced, and the accused was then taken into custody. Then the trial began, as I've mentioned, that took place in the Higher Regional Court of Frankfurt. The main accusation was involvement in 3 of these notorious massacres that took place, unfortunately, in Rwanda, in churches, where there were many Tutsi refugees who had sought refuge there on church grounds, and they were subject to attacks, and many people were injured and killed. And my client was accused of being involved in this massacre, in genocide, but as a co-perpetrator. And you have to remember that this is the first time that the Federal Criminal Police Office, the Federal Criminal Office had been involved in it. And it was the first time that the federal prosecutor had dealt with Rwanda at all. And in all of the investigations that I was involved in, it started with cooperation with the Rwandan judicial authorities, and investigations were carried out on the ground in Rwanda, and there were many, many witnesses. Witness statements had been compiled, and time again, they were heard in Germany as witnesses, and there are many implications of that. Firstly, you have to make sure that they can travel, and that means that they're facing a completely different legal system, a totally foreign country. For many of them, it was the first time that they had undertaken such a journey in their lives. So that was one aspect. Another aspect, which I think had played a huge role in practice, was also that those who were involved in the process, so the judges and the prosecutors, and all of the lawyers, were coming face to face with facts which they didn't actually know a great deal about. That's the first thing to point out. The second thing to point out, that there was it was the national law that had to be applied to a case that had no direct link to Germany. So you could say, on the one hand, it didn't play a role, and that was the stance that was ultimately adopted by the German judiciary, if I can put it that way, that they said that cases of universal jurisdiction, crimes against humanity, etc., that is a German that is a matter for the German criminal code, as it always has been. Now, that is perhaps fair and important on the one hand. On the other hand, it also makes it very difficult to be dealing with a completely foreign matter, which is being brought to a judge many, many kilometers away. It's not only that the facts are completely new, but also there's the whole social, cultural, and historical background, which differs dramatically as well. You have to look through reports, through official documents, NGO reports, and then also the witness statements that also have to be taken into the courtroom. And ultimately, that's the job of the court, is to look at the proof. And it's very difficult for judges, as I've mentioned, for judges who might not be familiar with the culture and the history of this particular country. It would be completely alien for them. Now, that makes the case particularly interesting, but it also makes it particularly challenging, especially because the judges, especially in Germany, as I imagine is the case in other countries as well, they weren't in a position to bring the main proceedings in the country where the facts had taken place. It was very difficult for them to create any sort of impression about what ought to be done. There were typical questions that came up when you want to look at the facts of a case. And from a procedural point of view, that's not always possible because the accused has to be there at the time. If the accused is not there, then that would be a cause for appeal. And of course, that's something that the court doesn't want, because they would like to they would like to come to a judgment that sticks. So of course, it was in their interest to travel to Rwanda and really to see, to look at, for example, what the church looked like, and to talk to the people, ask them what they had observed, etc., and also to make sure that there was consistency in the witness statements as well.
Ort anwesend zu sein, verzichten. Das heißt, dass das nicht stattgefunden hat.
So, what the judge, or what the court did, and something that I found particularly interesting, was that the Federal Criminal Office had been sent to Rwanda, and the defense was there as well. I was there, as well as a representative of the Federal Prosecutor's Office. They went as well. And these officials from the criminal office dealt with a whole amount of very technical matter. They had to take there was a 3D model produced of the events. That was also then presented or projected in the courtroom in Frankfurt. And all of these technical possibilities were used to be able to place a person on the model and to explain what this person would have been able to see, what they wouldn't have been able to see. Now, that might seem like a minor detail, but ultimately that was instrumental in this case. It was very important in this particular case to be able to beam people in, if I can use that term, and imagine what happened on the spot. And it was very interesting to get a real feel for what had happened and what the witnesses had talked about as well. From the beginning, the accused, and right to the end of the process, the accused disputed the fact that he had been involved in these attacks. The main proceedings, I think, lasted about 150 days of the main trial, but ultimately it lasted for over 2.5 years in total. And he had initially been sentenced as aiding and abetting genocide. There was a custodial sentence handed down. I forget how long he got, maybe 10 or 11 years for that. And then an appeal was lodged. So we, as the defense, appealed, but also the federal prosecutor appealed as well. So the Federal Criminal Office had to then take a decision. That's the supreme decision-making body in Germany. There's nothing higher than that. And they actually, they said that the facts had been established, but if the facts were as they had been presented, it wasn't really a question of being a complicit in genocide, but actually being a co-perpetrator. And there were consequences of that. It meant that the sentence had to be increased. It had to be referred to a different Senate also in the higher regional court of Frankfurt. And there was no new proof that had to be produced. It was decided that he was a co-perpetrator of genocide, and he was then given a lifelong sentence. And it was also established that this was a particularly serious crime. And that typically carries a lifelong sentence. And then further evaluations have to be carried out. But any particularly serious crimes are sentenced with about 22 to 25 years in prison. So that was the situation for Mr. Rwabukombi. What you can say about his case was that despite the fact that this case turned out very badly for him, it was certainly better than if he had been extradited to Rwanda, because I personally am convinced that he certainly would not have received a fair trial in Rwanda. The trial in Frankfurt, I would say, did have its stumbling blocks. There were a number of things that were very, very difficult to seek clarification on, given the distance. However, despite that, I would say that he did receive a fair trial, and that the judge's ruling in that case didn't approach it any differently than any other major trial with very complicated events that had taken place on German soil, let's say. So perhaps that's all I'll say about the case for Mr. Rwabukombi. I'd also like to talk to you about a second case that was also taken before the Higher Regional Court of Frankfurt. And this was against Mr. Taha. That's his first name. I'm not allowed to divulge his surname, but he's an Iraqi national. And the case came to Germany because, and this is an important reference here, since 2002, the German Criminal Code has been implemented, and part of that has been implementing the Rome Statute of the ICC, which is now, which is the founding blocks of the ICC. But the genocide in Rwanda had taken place in 1944. And the German Criminal Code was in place at that time. However, this rule could not be applied. So he was dealt with, he was tried according to the standard German Criminal Code, and there was a paragraph on genocide in the German Criminal Code before that date. Now, the case against Taha that was also heard in Frankfurt has a little bit of a pre-story. He had been to Iraq with a German national who had married according to Islamic law, and the couple, I was representing a Yazidi survivor and her 5-year-old daughter, and they had been kept as slaves by the couple. And alongside this trial in Frankfurt, there was also a trial in process against the wife. Her name is Jennifer. Again, I'm not able to divulge her surname either, but Jennifer is a German national who had traveled to Syria and Iraq and became involved with IS, and then came back to Germany and had a child, but then decided to go back. And in the run-up to her journey, she had made contact with somebody who'd also been a member of IS, or claimed anyway to be an IS member. However, he was a confidant, he was an informant working for the police, and she didn't know that. And this gentleman accompanied her on the journey. And when they were driving in the car, there were many things that were talked about. and she didn't know that she was traveling with an informant, but also that the vehicle had been tapped and the whole conversation had been recorded. And during the conversation, there was a whole amount of facts given away. There was a lot of proof, it was very damning, not only when it comes to the involvement with IS, but also how she'd become involved with Taha, and the fact that my client and her small daughter had been kept as slaves. Then the journey ends for Jennifer at an arrest stop in Germany, where she was then apprehended, and then she was accused before the Higher Regional Court of Munich. And I had to tell you that firstly to explain how this case had actually come to the court in Germany in the first place, because throughout all of these events, everything that she had been involved in, which was investigated, and there was an extract taken from her computer, all of the chats were downloaded from her telephone, etc., which meant that it was possible to identify her husband. And through the investigations, obviously I don't know the whole background, but the federal prosecutor then sent mutual legal assistance request to Greece, because he had traveled to Greece and had applied for asylum there under his own name. And the federal prosecutor then made a decision that despite the fact that there was no real connection with Germany there, and this is where the principle of universal jurisdiction comes in, that despite that, he was to be tried in Germany. So they traveled to Syria and Iraq. That's where this facts had taken place. The victim was a Yazidi, Iraqi national, in other words, and the small daughter as well, of course. And the place where the facts took place was Iraq. So this is a classic example of the pure principle of universal jurisdiction, which is something that hadn't been applied all that much in Germany either. So Taha was arrested in Greece. Of course, the Greek authorities had no interest in prosecuting him in Greece, so he was extradited to Germany. Why the local authorities had chosen Frankfurt am Main? Well, that was a very strategic decision, actually. It had to do with the flight that had been taken. He landed in Frankfurt and then was taken in there. So that was why the Frankfurt had been selected as the higher regional court for the trial to take place. The accusations against Taha were different to the ones raised against his wife. It wasn't about involvement in a criminal organization as such, but there were a number of accusations made against him, including genocide. That was the first that was the first condition. It was genocide against the Yazidi was the first charge, and then secondly, there were war crimes and crimes against humanity. And it's a very, very sad story that the 5-year-old daughter at the time of my client, unfortunately, died in Taha and Jennifer's household. And that meant that there was this was a criminal offense that had been committed against the daughter. She'd been tied to a window outside the house, and she died there. She at some stage lost consciousness, was transported to a hospital, or that was the claim made at the time, but then the child wasn't seen anymore after that. So there's no doubt at all that the child had died. So this means that along with the accusations of genocide, Taha was also being accused of murder, according to the German Criminal Code. The main witnesses in this case were our client. And again, just a few words about that, because I believe that my time is rapidly running to an end, but it's perhaps quite interesting to say as well, just how what happened to our client. There were many Yazidi women who had been sold as slaves, who had been raped and then imprisoned and then sought refugee status. And there's an NGO called YASTA, and they look after Yazidi. And every person, every woman coming back was interviewed, and to try to put together all of these different events and find out where the women had gone, which men had sold them, who they'd been sold to, how they had become slaves and how they had been abused, and so on and so forth. And that's what we did with our client as well. She had been interviewed by YASDA, by this NGO, and she told her story. And she told this dreadful story about how her daughter had died. And it was such an extraordinary story as to how her child had died in the full heat of the day, that it made an impression. It stood out from all the Yazidis who'd been interviewed. And this was a very clear example of what was happening to the Yazidi. And we heard this accusation that was made against Taha and his wife, Jennifer, and she was being tried in Munich. And we'd read in the press that the wife had not been involved in the death of the child. She'd claimed that she had not been responsible for the murder of the child. But it was said, well, I know who this is, or what this is about. And the prosecutor had actually no idea who the woman was, only what had happened, and on the basis of what Jennifer had told the informant. So the NGO had made contact with their lawyer, who had been dealing with the Yazidi for a long, long time. And so a contact was made with our client, and it was said that this criminal trial was going to be taken to Munich against Jennifer. And did she want to be involved as a witness, or did she want to become a joint plaintiff? Would she like to be involved in the main trial as a joint plaintiff? And that's what she wanted. That's where I came in, because a German lawyer was then required to be involved in this trial, to represent them. And that was how our client then ended up coming to Germany, was also involved in a witness protection program. And in both of the cases, in Munich as well as in Frankfurt, she gave a very lengthy witness statement. And I think she's the only real eyewitness that we have who in this whole trial. All of the other witnesses are investigators working on behalf of the Federal Criminal Office. They're experts. They know about IS. They know about the persecution of the Yazidi people and genocide. So perhaps I will leave it there. There's so much more to say about both cases, but perhaps I will leave it there for now. And I would be delighted if anyone has any questions, if I'm able to answer them. Thank you very much.
Thank you very much, Natalie. That was insightful. And I mean, you're a great storyteller. I mean, just like our previous speakers, but we want to hear more about what happened to the witnesses you mentioned. One thing that strikes me in cases of universal jurisdiction is the courage of witnesses and the importance of the role played by NGOs and civil society at large. You know, it seems to me that it involves a great deal of mobilization from civil society, but we'll probably talk more about this during the Q&A. So thanks again. So I learned how to say universal jurisdiction in German, Weltrechtsprinzip. And now we're going to hear about compétence universelle, because that's how you say it in French, universal jurisdiction, from Clémence Bechtart, who is a lawyer with the Paris Bar Association and the coordination of the Litigation Action Group at the International Federation of Human Rights, FIDH. What I think Clémence will discuss is how the French legal instrument in universal jurisdiction is more restrictive than in other countries, and in particular than in Germany. And I think she will also illustrate the point that it always takes a united effort on the part of NGOs, witnesses, and victims to bring those cases forward. So, merci beaucoup, Clémence, et je vous passe la parole. Over to you.
Thank you very much, Clémence. Over to you now. Thank you very much, Sylvie. And hello to everyone. First of all, I would like to thank the organizers. It's a pleasure for me to give this presentation to you today and share my experience as a French lawyer, so my experience of universal jurisdiction, UJ. First, I'd like to tell you the extent of UJ in France and how it's applied on international crime, torture, enforced disappearances, war crimes, crimes against humanity, and genocide. So UJ has existed for a long time in French law, and ever since the incorporation into domestic law of the 1994 UN Convention Against Torture in 1996. And we find the principle of audedere aut judicare that we mentioned earlier. Any person suspected of torture, if they are not extradited, can be prosecuted and tried in France if they are present on French soil. So that's that criterion of presence that is enshrined in the UN Convention that has been incorporated into French law. And that's the only connecting link requirement which is necessary for universal jurisdiction prosecution against people suspected of torture. And that is what gave rise to the first cases in France on the basis of universal jurisdiction, two main trials. First of all, in 2005 for acts of torture in Mauritania, and 2008 against a Tunisian perpetrator of torture. Both trials led to sentencing. And it's that same condition, that connecting link, the presence of the suspect on French soil, that was introduced at a later stage for the crime of enforced disappearance. In 2013, when French law incorporated into its national law the UN Convention Against Enforced Disappearances. But when it came to incorporating into French law the Statute of Rome, i.e. to apply universal jurisdiction for crimes against humanity, genocide, and war crimes tried by the International Criminal Court, the French Parliament decided that universal jurisdiction of French courts for these crimes would need to satisfy four extremely stringent requirements that are even more stringent than those provisions applying to the previously mentioned crime, and I'm talking about the presence on national soil. And so there were four very stringent conditions that were added into French law, mostly for political reasons. And this brings me back to what Hugo Relva was saying earlier. He was presenting this as one of the main obstacles to the exercise of universal jurisdiction, and that is the lack of political will. Since that mechanism had led to a number of cases being tried on the grounds of torture, well, it had led to reluctance on the behalf of the French executive powers, in particular the Ministry of Foreign Affairs. They saw that this was, they saw this as a hindrance to the exercise of French diplomacy, and therefore wanted to circumscribe the principle of universal jurisdiction. Now, I don't want to go into great detail over these four stringent requirements, one of which was cancelled a few years ago, thanks to the work of NGOs, including the FIDH, but there are still three very stringent conditions. First of all, not only presence on the French soil, but ordinary residence. Therefore, to bring a case against a person that is suspected of war crimes, crimes against humanity, etc., that person must, their place of ordinary residence must be in France. So not just present on French soil, but being a resident. Also, then, prosecution has become the sole preserve of the public prosecutor's office, and that places France in a situation of exception, since victims of the most serious crimes cannot initiate public action, cannot initiate prosecution, therefore cannot participate in proceedings as civil parties, whereas all other categories of victims for other serious crimes have that ability. So that is a significant exception, and the public prosecutor's office acts as a major filter on these crimes. So France's law on universal jurisdiction today is highly inadequate. It is much more restrictive than the international conventions that provide for this mechanism, and also more restrictive than what many other European judicial systems provide for. Sweden, Germany, the Netherlands, that have laws on universal jurisdiction, which are much more in line with what is provided for under international conventions. Also, since January 2012, France has now has a specialized judicial unit for the prosecution of international crimes. And I'd like to say a few words about that unit. Hugo Relva also mentioned this earlier. You can have excellent laws on universal jurisdiction as exist in a number of countries, but then no way to implement this in actual fact. And one of the conditions that can allow this is, for example, the setting up of special judicial units for the prosecution. The International Federation for Human Rights, other organizations of civil society have been pushing for the setting up of these special judicial units with special judges, prosecutors, specialized investigators to allow for the prosecution of these international crime cases. So for all cases involving a foreign dimension, either political foreign dimension, and also therefore to fight against international crime. Prosecuting these crimes requires a lot of expertise. It also requires a lot of interaction with NGOs. They often are the most active in documenting these crimes. This also requires interaction with victims who often are not located in France or the country where the complaint is brought. So that special War Crimes Unit was set up in January 2012. It's currently carrying out 150 investigations into crimes committed in 27 countries. They encompass cases prosecuted under universal jurisdiction, but also extraterritorial jurisdiction. That is to say, crimes committed by French nationals or against French nationals on foreign soil. So there's a commonality with universal jurisdiction, the foreign dimension, and the fact that we're looking at an international crime. So this is a paradoxical situation which mirrors universal jurisdiction and international criminal law. It's full of paradoxes. So an inadequate law, very restrictive law in France, but at the same time, a specialized judicial unit with prosecutors and judges who are specialized. That unit was set up only 10 years ago, and already they have on their docket about 150 investigations. So that's quite positive. Now onto the case that I wanted to give you details about. It has to do with Syria. And if I mention it today, it is because I'm sure you're aware, Syria is one of the most documented conflicts of our time, if not the most documented. As early as 2014, a large number of Syrian and international human rights organizations came to the realization that the only possible avenue to combat impunity was universal jurisdiction. In 2014, There had been attempts to refer the situation to the International Criminal Court via 2 draft resolutions submitted to the UN Security Council. Both of them were blocked by vetoes from Russia and China. And therefore, the situation is that it has not been possible to request the International Criminal Court to prosecute perpetrators in Syria. And so, having been denied access to the ICC on the one hand, and also in the absence of any real prospects of being able to lodge complaints in Syrian courts, victims turn to other countries and to a universal jurisdiction. So that was mostly human rights organizations and international human rights organizations that have filed lawsuits in these countries to initiate investigations and avail themselves of universal jurisdiction to address impunity in Syria. So I would like to mention one case, the Dabag case. It led to the first judicial investigation opened in France into crimes against humanity committed by the Syrian regime. I'll quickly address the facts of the case. We are looking back at November 2013, November 3rd, 2013, at midnight, a young Syrian student, Patrick Abdelkader Dabag, then 20 years old, who was a second-year arts and humanities student at Damascus University. He was arrested at his home in Mezeh on the outskirts of Damascus by Syrian officers who claimed to be from the Syrian Air Force intelligence services. And at the same time, the next day, those same officers returned to the Dabag family home, this time to arrest Patrick's father, Mazen Dabag. And according to witnesses, the father and son were both taken at separate times to a detention center at the Mezeh military airport, run by the Syrian Air Force Intelligence Service. The department is known for brutally torturing detainees. And according to the UN Independent Investigation Commission on Syria, the Mezeh detention center has one of the highest mortality rates of any detention center in Syria. Now, the father and his son have not been seen since 2013, so they are victims of enforced disappearance, and as such, their fate is one shared by tens of thousands of Syrians who've been arrested and detained by the Syrian regime and who are still considered as having been victims of enforced disappearance. Now, in this case, Mazen and Patrick Abdelkader's had dual French-Syrian citizenship. That's one of the specific features of this case. And it's on that basis that a judicial investigation began in France. So therefore, the grounds was not universal jurisdiction, but the grounds were passive personality jurisdiction, i.e. one of the 2 victims, in this case, both victims, had dual French-Syrian nationality and were victims of a crime committed in Syria. So why did I choose to tell you about this case? As you remember, in France, there are very restrictive criteria to apply universal jurisdiction, but the particular characteristics of the Dabag case made it possible to overcome those stringent conditions and to initiate a large-scale investigation into the crimes of the Syrian regime. Without that dual nationality, there would have been no investigation. And that principle of passive personality jurisdiction also led to the lodging of a complaint on the use of chemical weapons by the Syrian regime, and that also led to the opening of a judicial inquiry. Now, the filing of a complaint and the opening of a judicial investigation for torture and forced disappearances constituting crimes against humanity took place in 2016. So the complaint requested immediate judicial investigation through the appointment of an investigative judge into the crimes of enforced disappearance and torture amounting to crimes against humanity against Mazen and Patrick Abdelkabir by members of the Syrian regime. And less than 2 or 3 weeks later, the prosecutor agreed to open a judicial investigation, and investigative judges were appointed. They agreed to collect testimonials and to study the chain of command of the Air Force intelligence, one of the 4 units in charge of the repression against the Syrian population since 2011 and responsible for the arrest of Patrick and Mazen Dabag. There were many challenges in this case that we supported, including gaining the trust of witnesses and victims to get them to testify while ensuring their safety. So this case was brought to court thanks to the support of NGOs. Now, there had been a structural investigation that was also opened in Germany at more or less the same time, and that was an opportunity to collect testimonials from victims, from witnesses in Syria who came to explain the acts of the Syrian regime, but also to testify about the practice of systematic torture of detainees, thus constituting crimes against humanity on the one hand, and on the other hand, to shed light on the chain of command and therefore to identify the most highest placed perpetrators or persons responsible within the Syrian regime. 2018 was a really pivotal moment 2 years after the lodging of the initial complaint. In early 2018, Syrian registry offices began issuing thousands of death certificates for people who had been arrested and who had then disappeared. And thus in July 2018, the Dabag family received formal notification of the death of Patrick and Mazen. And according to the documents received, Patrick Abdelkader, the son, died on 21st January 2014, soon after his arrest, and his father's death took place almost 4 years later. And according to information, it occurred on the 25th of November 2017. The investigative judges felt that this was proof that Patrick and Mazen had indeed been arrested by the Syrian regime. And on the basis of that information, on the 8th of October 2018, the investigative judges in charge of the case issued 3 international arrest warrants for complicity in crimes against humanity, first against Ali Mamlouk, considered as the second ranking in the Syrian regime after Bashar al-Assad. As we said before, Bashar al-Assad is a head of state in office and therefore cannot be prosecuted by an international court, but his subordinate was. And he had been at the National Security Bureau since 2012. The second arrest warrant was against Jamil Hassan, who was director of the Air Force Intelligence. I mentioned that that was one of the 4 repressive units of the Syrian regime. He was one of the pillars of the security regime. He is also under EU sanctions since 2011. And the third arrest warrant issued by the French judges was against Abdel Salam Mahmoud, who at the time was director of the investigations branch of the detention center where the 2 victims had been detained, Patrick and Mazen Dabag. So these international arrest warrants were in parallel to another international arrest warrant against Jamil Hassan for crimes against humanity by Germany. And so those are really historical arrests and decisions. This led to the opening of a historic trial in Koblenz in Germany against other Syrian regime officials. And definitely these are very important milestones in the work done by Syrian organizations and activists to ensure that judicial investigations could begin against Syrian officials for crimes against humanity. So what are the next steps? In the Daba case, although the international arrest warrants will probably not be executed because the officials would need to leave Syria, and we know that the Syrian state will never agree to hand the suspect over to the French justice system. However, the investigative judges could nevertheless consider closing the investigation and sending the case to trial. So organizing a trial in absentia in France against these three people suspected of crimes against humanity. And without access to the ICC or aspects of any prospects of justice on Syrian soil, these cases show that extraterritorial justice send a strong signal. These cases send a strong signal that extraterritorial justice has an essential role to play in pursuing those responsible for the gravest crimes perpetrated in Syria since March 2011, and no hybrid tribunal can, in the state of things, be set up. This also demonstrates that these investigations are possible, that they can produce concrete results, even when extraterritorial judges in France and Germany don't have access to Syria. But working with NGOs and working with victims and witnesses by setting up a relationship of trust, they can issue international arrest warrants. And this is only made possible by the huge courage demonstrated by victims and witnesses and Syrian activists. And I think it's very important because this underlines the very important role of universal jurisdiction in providing a balance in terms of international law. However, there are still very many obstacles. And I would be very happy to continue the discussion during the conversation. If you have any questions, I can certainly provide more details. And that'll be it for me at this stage.
Thank you so much, Clémence. Yet again, another very interesting presentation on the French system and this contradiction you highlighted between, on the one hand, the desire to try and bring more obstacles for people to be able to prosecute, while on the other hand, creating mechanisms like this unit you referred to. Another interesting
I have
point,
a question.
Just a second, please. Another interesting
Sorry.
point I think you highlighted is the fact that the crimes in Syria are extremely well documented, and that there's a huge amount of evidence. And I wonder whether universal jurisdiction is a principle that can be used more now, thanks to technological progress in a way. I mean, the technology makes it possible for people to sift through documents and extract relevant evidence, something which maybe would not have been possible 10 years ago or 15 years ago. But again, something to ponder for the Q&A. Before I give we're not opening the floor for questions yet, sorry, sir. We're going to give the floor to Olga Kavran, our last speaker, and then you can ask questions. Thank you for your understanding. So Olga Kavran is the founder of Justicom, which is the first NGO dedicated to communicating justice. And this is also something that's very important when it comes to knowing what the purpose of justice is. Serving justice includes making the trials visible and giving access to the victims and to all of the parties and all those affected. And we wonder whether or how this can be made into a reality when trials take place so far away from the crime scenes. So I'll give you the floor to Olga now. Thank you very much, Olga.
And thank you very much for inviting me. I presume everyone can hear me well and can see the screen. So yes, I will be speaking about communications challenges. I am currently in Beirut, overlooking the port where the horrible blast took place. And unfortunately, this may also have to become a case under universal jurisdiction, because it doesn't seem like victims are going to get any justice in Lebanon, regrettably. But that remains to be seen. So in the latter half of the 18th century, Jeremy Bentham spoke of the darkness of secrecy and the lack of publicity that leads to a lack of justice. In the intervening 2 centuries, the notion of publicity has undergone some rather dramatic changes with the advent of electronic, of course, and later social media. And what I will speak about is legal principles. This is important to note because a lot of the times the publicity of proceedings is seen as almost like an add-on and something that is nice to do and a very altruistic thing to do vis-a-vis the victims. But in fact, it's actually a very strict legal obligation. And I will explain this in the next few minutes. So what are the rights at question? We have the right to a fair and public hearing, which is mainly the right of an accused not to be judged in private or in secret. However, it is also the right of the public to be able to follow the work of the courts, and it guarantees publicity, or rather transparency, of proceedings. Another right that is relevant is the right to information. And the right to information, I will speak about all of these in a few moments, is also there to guarantee transparency of the work of public bodies. And finally, it is the arguably emerging right to truth. Again, I will explain all of these in turn. So the right to public hearing is enshrined in all the major human rights documents as one of the basic rights of the accused. You see examples from Article 14 of the ICCPR and Article 8 of the American Convention on Human Rights. The UN Human Rights Committee, in its general comment on Article 14, has pronounced that all trials must in principle be conducted orally and publicly, and that publicity ensures transparency and provides an important safeguard for the interest of the individual and the society at large. They also stated that the hearing must be open to the general public. And then there are instances, of course, in relation to protecting the witnesses, for example, or some national security information in which the public can be excluded, but these must be provided for by law, and the decisions in respect of them must be clear and rendered by the judiciary. A number of court cases brought before the European Court of Human Rights have reaffirmed this right. Some stated that public hearings are one of the main means whereby confidence in the courts can be maintained. Publicity contributes to the achievement of holding a fair trial, and the public. And then they also went into some detail as to how this right must be guaranteed. For example, the public must be informed about the date and place of a hearing, and the venue must be easily accessible. They also went into some more detail in other cases where the detained applicant alleged he had not had a public hearing because the trial was held in prison, the court ruled that he was in fact right and then stated what must be done, including, for example, and particularly relevant to these cases of universal jurisdiction, which are by definition far away from the areas where the crimes were committed, or cases before the international courts as well. For example, this notion that expensive transport to a remote location had a clearly discouraging effect on potential spectators wishing to attend the trial, stating that the authorities in question should have provided regular transportation for spectators for the duration of the trial. Now, imagine the implications of that at the international courts, for example, or again, courts of universal, or rather national courts that exercise universal jurisdiction. A related right, which is related to the freedom of expression, is the right to information. And again, it's stated in Article 19 of the ICCPR. And then the special rapporteur for the protection and promotion of the right to freedom of opinion and expression clarified that this is not simply a corollary of the freedom of opinion and expression, but that it is a right in and of itself. So the right to information. It also, the three mandates for according to the three mandates for the freedom of expression, everyone has the right to seek and impart information, but this is also a positive obligation on states to ensure access to information. Very important point. Again, it's a positive obligation on states to ensure access. And they also refer to it as a fundamental human right. Okay, these are the three mandates, special mandates on freedom of expression of the UN, the OSCE, and the Organization of American States. They state, for example, that public authorities should be required to proactively, even in the absence of a request, provide a range of information of public interest. They talk about systems that should be put in place to increase access to information. What is interesting to note as well is that freedom of information laws, which are meant to in fact ensure that states honor the right or guarantee the right to information when it comes to the work of public bodies, and here judicial bodies are included, of course. These laws, in 1990, only 13 countries had passed such laws, whereas now that number is very close to 120 countries, recognizing the need to have a very regulated means by which the public can get information about the work of the governments. And this is, if you look at the timeline, also interestingly, a parallel development to international criminal justice. And finally, we can speak about the right to truth. And some would, it's arguably an emerging right still, and it refers to the set of principles for the protection and promotion of human rights to action to combat impunity, which reaffirm the inalienable right to know the truth vis-a-vis gross human rights violations and serious crimes under international law. And then they refer to the Office of the UN High Commissioner for Human Rights, refers to international criminal tribunals as constituting important tools for ensuring the right to truth. And of course, this is very important when it comes to mass violations of international law, which again are the types of cases that are likely to be processed through universal jurisdiction. And I would argue that a corollary of this, or rather an analogy to this, is that where international criminal tribunals constitute important tools, so do national courts in the cases of universal jurisdiction. And the special rapporteur, for the first time appointed in 2011 on the promotion of truth, justice, reparation, and guarantees of non-recurrence, stated that in the aftermath of repression of conflict, the right to truth requires states to establish institutions, mechanisms, and procedures that are enabled to lead to the revelation of truth. And again, by analogy, we can certainly include cases of universal jurisdiction and states that exercise such jurisdiction in this context. So again, to recap, we have the right to a fair and public hearing, mainly guaranteed to the accused, but also to the public to be able to follow proceedings. We have the right to information, of people to inform themselves of the work of public bodies. And then we have the right to truth, which is particularly related to serious violations of human rights. Now, what is not clear from the legal framework is what does public mean, in fact? What does it mean to conduct a public hearing? Now, in a national situation, in a national case, it might seem obvious. You have a public gallery. Whoever is interested can, under certain restrictions, obviously, come and observe the trial, and there you have the guarantee of a public hearing. However, when we're speaking about international tribunals and when we're speaking about national courts with exercising universal jurisdiction, as all the previous esteemed speakers mentioned, these happen very far away from the countries in question. You had cases in Spain dealing with Argentina, you have cases in France and Germany dealing with Syria. So obviously talking about a courtroom where you have a public gallery as being sufficient to conduct a public hearing, one could legitimately question whether that is in fact, whether that would in fact satisfy the publicity element. What about information about the cases? What about languages? And so on. What if the journalists who follow the trial and on whom the local population relies to read about the trial are unable to come because they do not have the means, the resources, or are unable perhaps to obtain visas to enter the country in question? Again, these questions were first raised in connection with international courts, and they're very relevant to the work of international courts, but they're also relevant to the work of national courts dealing with universal jurisdiction. Now, the way international courts have dealt with these issues is by first, of course, guaranteeing the right to a fair and public hearing in the statutes and the rules of procedure and evidence. And then also going, which is interesting, this is something that started at the Yugoslav Tribunal, the ICTY, very long time ago, which was very insightful. In fact, they displayed great foresight by establishing a public information office from the outset in 1993 when the tribunal was created, understanding the need to communicate with the public about the work of the tribunal. And this is something that the ICTY did way ahead of any national courts actually appointing or having any public information offices. In fact, many national courts still don't. What has then happened as times have evolved is that, of course, electronic means have been introduced in terms of disseminating the information to the public. So each court now has a website which can provide a broadcast of live broadcast, which is actually a 30-minute delayed broadcast of proceedings in various languages. They also provide press releases and media advisories, again in various languages, as well as a number of regulatory and other public documents, statutes, rules of procedure and evidence, and so on. Some courts also usefully provide summaries of witness testimony, as well as main decisions. Some of these summaries are written. Sometimes they even provide audio-visual summaries and various case-related information. They have appointed spokespersons to communicate with the media, again, in the official languages of the court, but in the case of the ICTY, also the language of the accused, because ICTY, the official languages were English and French, whereas the accused, of course, didn't speak either. But the court from the outset was providing information to the public also in the local languages. And they, of course, have outreach departments, which are tasked with establishing two-way communication with different communities and explaining the work of these institutions in more detail in particular ways tailored to these communities and specialized groups. So this is how the international courts and tribunals have addressed this issue. And it's very important to point out, because my argument is that national courts exercising universal jurisdiction should look to international courts and learn from the best practices in terms of communicating their work in order to do so themselves. Now, in terms of national courts, I've only, in the interest of time, actually, I will only speak about Germany at the moment and the Koblenz trial and what rules are in place in that sense. So in terms of the overall rules, right, in Germany, the Courts Constitution Act basically prohibits the audiovisual recording of proceedings, which is, again, completely the opposite as to what happens at international courts, where you have a live broadcast of all non-private or non-closed sessions, of all the open sessions of court. It says that audio transmissions to the workspace for persons reporting for the press may be authorized by the court. But then you have the issue of language, because under law, the courts they're obligated to provide interpretation for the accused, but not for the media sitting in the public gallery or any such space that is set for them to work from. Now, they also state that audio recordings of any proceedings that were authorized for academic or historical purposes will only be so if they are of paramount significance for the contemporary history of the Federal Republic of Germany. And they may not be disclosed for other purposes. They may then be transferred to the federal archives or the respective local archives, but if they're not accepted by these archives, they will be deleted. So there's no mention of any interest of the victims or anyone else specifically related to the cases. So what happened in the Al-Khatib trial in Germany, it required a constitutional court intervention for journalists to be provided with interpretation into Arabic. And basically all that it required, to the best of my understanding, is that they simply needed to provide additional headsets for the journalists, because the interpretation was already being provided for the accused. So it wasn't exactly complicated, but somehow it seems that the trial judges did not see it as necessary. And then the Constitutional Court was petitioned and intervened. And the judges very recently denied the request to even record the closing statements. So there was issues raised about how the recordings might impact witnesses and so forth, but this did not come into play when it comes to closing arguments. And even though that was not an issue, the court still denied it, stating that although generally historical, the trial is not of significant importance to Germany itself, which the court considered a requirement. You can clearly see the problem with that proposition, because obviously the court is of significant importance worldwide, and it's certainly important to Syria and the Syrian victims. So what happens in the Al-Khatib trial is that public
Okay, I'm sorry about this. Olga, I think, can you hear us?
Yes, I can, yeah.
Okay, great. I think it was just for a few seconds. You may continue.
Okay, all right. In fact, this is I will conclude with this. So currently, the information is being provided by NGOs and others. There's a podcast called Branch 251, which is very interested, that produces episodes in English and in Arabic to talk about the trial. There's any number of reports by Trial International, as well as their annual reports, and so on. So there are sources of information about the trials, but none actually, as far as I can see, that come from the court itself. And in my personal view, this is hugely problematic. So I will end here and will be happy to answer any questions, but basically what courts of, or countries in which courts exercise universal jurisdiction of this nature should look to international courts to set up systems of providing public information to the interested parties, to the victims primarily. Thank you.
I have a question.
Thank you very much, Olga. Sir, can you please wait? We will give you the floor in a little bit.
I will wait. Thank you very much.
Thank you. Yeah, thank you very much for raising the fact that the publicity rules in national trials are different from what they are in international courts, and that this in turn raises some legacy issues because the archiving system is different, or because you do not do the type of audiovisual recording you do in international courts. We are going to open the floor for questions. I'm handing over to Annie, and maybe Annie, we can start with the question from the gentleman who's been waiting, and then turn to Slido, if that's okay with you. Thank you.
Yes.
Thank you very much for your courtesy. My question is for the French lawyer, Mrs. Beck-Tart. Okay, can I ask my question?
Yes, please go
Hello?
ahead. Yes, you may in English, please, because
I will ask it in French.
Thank you.
It's a generic question regarding Syria. Maître Beck-Tart.
Sorry, excuse me. Excuse me. We had interpreters for the presentations only. Sorry about that. We do not have a full team.
I will ask my question in English.
Thank you.
I hope the French lawyer understands English.
Yes, she does.
So, yeah, okay. So the question, and also doctor or the lawyer, Mrs. Olga Cabran, I think it's everybody, in fact, all the legal experts here. I mean, a lot of apparently called UJ, not necessarily lawsuits, but actions, let's say, I don't know, maybe not even in a legal sense, against Syria, okay, for various crimes against humanity. Now, the question is there any recourse on the part of, I don't know, the UN, but the problem is that I don't know if it gets blocked by Russia or something, against Syria in front to seize the ICC? That's the question.
Sorry, I don't think I got the question. Could you repeat it, please?
The question is the following. There have been many crimes against humanity carried out in Syria by Syrian authorities. Now, is there any recourse by the UN or other bodies to bring action?
Yes, okay, now I got your question. Is there any recourse to bring the Syrian situation to the International Criminal Court? Unfortunately, the only way to get an investigation started at the level of the International Criminal Court concerning Syria would be a referral by the Security Council of the United Nations. And that is because Syria hasn't ratified the Rome Statute. Syria is not a party to the ICC. And therefore, the only way to seize the International Criminal Court is to get a resolution from the United Nations Security Council, like it has been done, for example, in the cases of Sudan and Libya, where these cases have been referred to the International Criminal Court by the UN Security Council. And so attempts have been made back in 2013 and 2014, resolutions presented by France and other countries. I think the UK also sponsored these draft resolutions that were submitted to the United Nations Security Council and that were vetoed by Russia and China. The attempt has never been made since then, but of course we know that this would oppose Russia's strong opposition, and again a veto. There's a strong blockage at the level of the Security Council regarding the whole situation in Syria. I mean, even resolutions concerning humanitarian aid and access are difficult to get voted within the Security Council. So this was the only way, and this is why there's very little hope in the near future that the International Criminal Court could open an investigation on the situation in Syria.
I have a follow-up question related. I understand the answer, it's excellent, but can I ask a follow-up question?
Yes, please do, and then we'll take somebody else's question.
Yes,
Thank you. Thank
you. I understand that Russia is blocking any action against Syria at the United Nations Security Council, but isn't there any other way of getting Syria to the docket? I mean, via, I don't know, the International Federation for Human Rights, other organizations, public opinion, that something has to be done against these dictators.
Unfortunately, no, there's no any other way. And again, you know, there's been a lot of attempts and strong advocacy in this regard. But unfortunately, these are the rules of the Rome Statute, and the International Criminal Court can only have jurisdiction in cases where the country where the crimes are perpetrated has ratified the statute, or where nationals that are involved in these crimes come from a country that has ratified the Rome Statute. And if these conditions
so basically you're saying that the ICC is completely, I don't know what the right word is, but you know, the Rome Statute and whatever, just forget the ICC. Is there any other way of bringing action against Syria and other such countries?
Excuse me, I think that we're going, I mean, I'll leave Clémence answer this one, but then please, Robert, we'll move on to the next
I shut up.
Thank you.
I shut up.
No, but I do understand your insistence when we see, you know, the scale of crimes that were committed, not only by the Syrian regime, the level of documentation, and I do understand that it's very unsatisfying that we have only as a legal recourse for the moment these very narrow avenues under the universal jurisdiction, but this is all we have for now. There has been also the creation within the United Nations system of the AIIM, a mechanism that was created by the General Assembly of the United Nations to bypass this inability within the Security Council to act on the question of impunity in Syria. So this mechanism is not a court, but it is a mechanism that has been tasked of collecting evidence, gathering and preserving evidence of all crimes committed by all parties in Syria, and will maybe be the basis in the future for a special tribunal or for any effort of transitional justice in Syria. But unfortunately, there's no other way. I'm sorry, I don't have a better answer to give you.
Thank you very much,
Thank you
for your reply.
Thank you for your excellent yet completely unsatisfactory answer.
Thank you. But I wouldn't be that pessimistic, Robert, because I think that if even when an international court, let's say, cannot be seized because of a blockage in the Security Council, there are other mechanisms, and everyone plays their part. I mean, Clémence mentioned the AIIM, the mechanism for Syria, and I know that the AIIM contributes to investigations, and they work together. I mean, with civil society, with witnesses, and with lawyers from different countries. And so I think that there's room for hope. Maybe I'm being naive, but that's the way I am. All right, and now hand over to Annie. Thank you.
Yes, thank you. While we have Clémence on the spot, can we ask you to explain again the difference that you made between extraterritorial jurisdiction, compétence extraterritoriale, and UJ? Thank you.
Yes, of course. I'm sorry if it was not clear enough in my presentation. Well, let's say that universal jurisdiction is everything that was presented to you in the first session, meaning no link between the state where the complaint is filed and the crimes committed. The extraterritorial jurisdiction and covers active personality jurisdiction and passive personality, meaning cases where crimes have been committed in a foreign state, but by nationals from the country or against nationals of the country. Very concretely, to take the example of France, extraterritorial concerns jurisdiction concerns any crimes committed against French citizens or dual citizens abroad in a foreign state, or by French nationals or dual nationals in a foreign state. Mm-hmm. And why it was important to also tell you about this extraterritorial jurisdiction, although I guess it can complexify things, is that when it comes to the prosecution of international crimes in France by this war crimes unit, they take both criteria of jurisdiction to try to open, and we do also as lawyers and civil society actors, to try to get investigations opened when we know that a pure and only universal jurisdiction case could not be opened. So this is why we try to create the conditions to get investigation open through the application of extraterritorial jurisdiction, meaning a link with French victims or French suspects or dual nationals again.
And while we are on that, a follow-up question maybe. Does the rising number of UJ cases in France, you mentioned 150 investigations, mean that in France, or that France could reduce its involvement in international courts with the ICC, for example?
Well, we do think that both are very much linked, and that French commitment to creating a war crimes unit, to giving more resources and means to this war crimes unit, is complementary to French commitment towards the international justice system as a whole, I mean, and towards fight against impunity. Although we know, again, that this political willingness can be very ambiguous. And we have talked also before about the political obstacles, but also of, you know, this, well, partiality, I would say, of the international criminal justice that can easily go after suspects of weak states, but has very much more trouble when it comes to suspects from powerful states. So there lies also an ambiguity of any, I think, political willingness, France or any other country, in favor of international criminal justice. But we think that these are very complementary.
Mm-hmm. I have another question still for you, for Nathalie this time, I think. You mentioned the cultural challenges that are present when a tribunal in Germany takes on a case on Rwanda, for example. Wouldn't it be much easier for Germany then to surrender these people to the ICTR? So International Criminal Tribunal for Rwanda.
Yes, well, I've worked at the ICTR, and I wouldn't say that these problems didn't exist in the trials at the ICTR, because of course there as well the judges were international judges, and prosecutors were international prosecutors, and lawyers were international lawyers, be it yes, I mean, I was on the defense side, so there were no Rwandans implicated. But in the very specific case that I have mentioned, there was an obstacle in the sense that the International Criminal Tribunal for Rwanda has never been interested in my client. There was no investigation against him, there was no indictment against him, there was no evidence against him. Which of course was of very much interest for us defense lawyers while we defended him here in Germany. But in theory, of course, you're right. There were other Rwandan mayors, bourgmestres like him, who were accused, who were prosecuted, sorry, by the ICTR, but that just wasn't the case for our client. And I mean, from my memories of being a legal assistant for the defense at the ICTR, I would say that these cultural clashes still existed. Of course, it makes a difference. It makes a little bit of a difference if the composition of the trial chamber is more mixed, you know, people coming from many different countries. And of course, we were much closer to Rwanda, just geographically, which also made a lot of things easier. But at the end of the day, I would say that I think these cultural clashes, if I may call them like that, are they're not avoidable, but that doesn't mean, you know, that I mean, that's not reason enough to say let's not have international trials far away from the situation countries. A much bigger problem, I think, is the outreach and everything Olga has mentioned, actually. And I have to say that the decision that the Higher Regional Court of Koblenz took is, for me, I mean, it's understandable for me, being a German lawyer and knowing how German lawyers think and how much they stick to their, you know, to what they know, and how small the openness is, just, you know, to yes, maybe to adapt to a new situation. Bringing universal jurisdiction cases doesn't mean that you have to change the rules of procedure and evidence, but for example, the publicity of the trial and some kind of outreach, which would be quite easy to organize and doesn't mean, you know, a lot of resources, I think is something that they really have to look into. But that's the way it is, you know. There is no transcript, there is no simultaneous translation for everybody. Very often it's just a consecutive translation, and just for the individual concerned, be it the witness or the accused, of course, who always receives a translation. But, you know, just like this, the interpreters sit next to the accused, and it's like, you know, I mean, it's got nothing to do with what you have at the international tribunals. And the same for the transcripts. I mean, just the recording of the whole case. When I sit there in the courtroom, I have my laptop with me and I'm typing the best I can to catch what's being said. And I mean, this is really middle age, you know, but this is Germany in the 21st century. And of course, we have exactly the same issues, just with national trials, big trials. And it's not about to change. I mean, the bar associations have been advocating for this, I think, like for 50 years, and nothing is moving, which is very, very unfortunate. Yeah.
Sorry, Annick, may I come in? Olga would like to say something. Go ahead, Olga.
Yes, just perhaps to add a positive example is how the Dutch courts have dealt with the MH17 case.
Yeah. Mm-hmm.
Which, in terms of communications, they've done an incredible job of recognizing the fact that this case concerns people outside of the Netherlands. So they've provided information in English. They've provided a lot of different, you know, and they came. I don't think I'm disclosing something controversial if I say that they consulted with experts from international courts before they set everything up, precisely to be able to achieve that. And then they've tried to emulate what the international courts have done to the best that they could do in terms of providing information on a website, providing summaries of decisions, and again, providing information both in English and in Dutch for the interested public. So that it's worth mentioning a positive example. I didn't want to, of course, go into too much detail during the presentation, but there are ways to do this. And as Natalie pointed out, it doesn't require a great deal. It requires just a bit of understanding of the situation and lessons learned. I mean, there's a lot of information out there. There's a lot of experience out there from international courts, not all of it good, obviously, but again, from these mistakes, a lot can be learned as well. So there is, if there's a will, there is definitely a relatively easy way to achieve these things.
May I say that on this question of simultaneous interpretation during international trials in front of national courts, AIIC is trying to promote the use of simultaneous interpretation as well. To our level, we're trying to do something on that as well. Well, other questions?
Can I just jump in, Annie?
Yes, please.
Okay. I was asked to also ask the questions who got the most votes on Slido. So that would be a question about a case which is prosecuted in France and Germany, a Syrian chemical attack, which will have jurisdiction. Can the trial take place in country 1 using applicable law from country 2? Who wants to answer this, take this question?
I'm not sure I get the question right. So is the question, can the trial take place in country 1, for example, being Germany, but using Syrian law, or?
That's how I read it, or French law maybe.
French law. Because
okay.
it's in the
French
case
law.
of this investigation on the alleged use of chemical weapons in Syria.
Yes, yes. Well, I know about the case because, like Clémence, I represent the NGOs in Germany, and she does in France. But of course, the applicable, I mean, in a German courtroom talking about Germany, the applicable law would always be German law. So it can just be the regular criminal code, and of course the Code of International Crimes that I've mentioned before, that was enforced in 2002 for genocide, crimes against humanity, and war crimes. So there is no legal possibility to have a trial in Germany based on foreign law, on the application of foreign law. That's not a possibility.
Because my understanding was that these are investigations taking place on the same case, but maybe not. Maybe it has to do with 2 different instances. I'm not sure. So in which case, if it's a concurrent investigation in 2 different countries, I wonder whether there would be some competition at some point between France and Germany for this one, for instance.
Well, hopefully not competition, but cooperation.
Mm-hmm.
Yes, exactly. And I think that, you know, the Germans and French have already teamed up and decided to do a joint investigation concerning Syria, more general, not related specifically to the use of chemical weapons. And this really for them is more about better cooperation, exchanging information, evidence, also allowing, for example, the French to have more easily access to witnesses or victims who are present in Germany, etc. So there are precedents of cases, for example, a Rwandan suspect of genocide who was both prosecuted in France and Belgium because there were grounds for jurisdiction in these 2 countries. And finally, the French decided that the Belgians were more ready to prosecute the case and to bring it to trial, and decided to close their own investigation and to let the Belgium organize the trial. So this has happened before, and I think that especially in this field, the war crimes unit across Europe are cooperating more and more, and seeing this never in terms of competition, but as Nathalie was saying, really a cooperation and trying to maximize also their investigations.
Thank you very much. So I'll continue with the next question that got 4 votes. Do general principles of criminal responsibility refer to universal values? Enlightenment. Is this culturally acceptable? And what about the different perceptions? Anyone for this question? The general principles?
Or should we keep it for our after session over drinks? Because this is very philosophical.
Okay.
It can go on forever.
Annie, would you like to do the next question then?
Yes. So I had a question about whether you expect more cases against Syrians in Germany or in France in the future years.
Well, maybe it's wishful thinking. I hope. But it's also, and we haven't talked about this before, but it's also very much a question of resources and therefore also of political will. I wouldn't say that the political will is not there, but I mean, talking about Germany, we have a war crimes unit with about 14 or 15 prosecutors. That's it, and maybe, I don't know, like let's say 40 investigators working for the federal police in the Department of International Crimes. So you can already see from the human resources that it's quite limited. And I think they already have, I mean, of course, I don't know because it's not public, but I assume they already have quite a lot on their plate. So I would say that the approach of the Office of the Prosecutor General is very much in favor for pushing more investigations. But the Ministry of Justice may somewhat put the brakes because it's just practically not doable. Yes, I think the will is the general will is certainly there for Syria, especially because, I mean, what Clémence has really explained very well, there are no other avenues at the moment than universal jurisdiction cases or national jurisdictions to take over these investigations and hopefully trials one day. And as we have a huge community now of Syrians in Germany, and of course a lot of potential witnesses and certainly a lot of victims, and maybe and surely actually also some alleged perpetrators. Yes, I mean, I think we really want to move forward with this, but you can already see with the trial in Koblenz, you know, what a big task it is. So I think you just have to keep this in mind. It's like the ICC. The ICC makes choices, and the German Prosecutor General makes choices, and he's politically dependent on decisions of the Ministry of Justice. I don't know if it's the case in France as well, but there are some limitations in what they can decide for themselves.
Clémence, do you want to reply to Nathalie or about France?
Oh, I totally do agree with what Nathalie just said. I mean, the situation is the same in France and elsewhere in Europe. A lot will depend on the resources that will be given to these war crimes unit to be able to start new investigations and to identify and prosecute suspects. A second trial will be open in Germany soon concerning another Syrian suspect, a doctor this time, again for crimes against humanity. So this is a good sign also. From what I know and the work we are doing with Syrian NGOs, complaints are still being filed across Europe. New investigations are being opened, although they are not public. So yes, we have good hope that this is a trend that will continue and that there will be more investigations and hopefully more trials across Europe.
Thank you. I see that Eva has been asking for the floor for a while. Go ahead, Eva.
Thank you very much, Sylvie. First of all, a big thank you to our wonderful speakers and excellent interpreters, sign and speech. Thanks very much. My question refers to the following. You probably know that there have been courts in the Netherlands working under foreign law. Lockerbie comes to mind, Lebanon, now Kosovo, of course, different circumstances. But would that be thinkable in another jurisdiction, in another country, to just establish a court or surrender territory to work under foreign law? Thank you.
Well, this would really require the creation of something like another special tribunal. At the Special Tribunal for Lebanon, for example, yes, you're right, it was located in the Netherlands and they were applying Lebanese material law, not procedural, but material law. But that was that was like a special institution that at the end of the day happened to be located in the Netherlands, because the Netherlands are very smart, are very smart about, you know, taking these tribunals to their countries, because yeah, I mean, they have become like The Hague has become like the place for international tribunals, and the Netherlands provides for the facilities and is very supportive of that. So of course, if you were to have a special tribunal for Syria, which of course we would all hope for, but that again is complicated, because you may need a Security Council resolution to create such a tribunal, which you certainly won't have with the current composition of the Security Council. But if there was to be a special tribunal for Syria one day, then of course, independently of where this court would be located, be it in Germany, France, or again in The Hague, foreign law, be it Syrian law, could be applied. I mean, that's one option. That's then for the people who create this tribunal and to draft the rules to decide on what basis they want to move forward.
If I can just add to that, there's the Kosovo Tribunal is a good example of what the EU can do when it wants to. So it's not necessary only for the Security Council to do it. There were other instances, you know, the STL was established by a Security Council resolution, but it was initially intended to be established as an agreement between the United Nations and Lebanon. Which was the basis of the establishment of the Sierra Leone Tribunal. So there are different ways. Then there's the special court in the Central African Republic, which is an internationalized court, but based locally. So there are many different mechanisms by which the international community can actually act. There was the Hissène Habré trial, which was held at a court that was established by the Organization of African States. So there are definitely different mechanisms. I would definitely share some modest optimism with Sylvie in terms of there are ways for this to be handled that don't rely on the UN Security Council and don't suffer from the possibilities of a Russian veto. But for that, we need other governments to want to actually do something about this. And again, I go back to the Hissène Habré example, because that trial only happened because of about 10 years of very pointed, very focused activism from victims assisted by Human Rights Watch. Otherwise, it wouldn't have happened. And so, unfortunately, this is what's required in the case of Syria. This is also what's required in the case of the Beirut blast, which I mentioned at the outset. Unfortunately, now it is really, we cannot expect at the current political climate governments to proactively do a lot of things. But at the same time, I think that activism brings results. And even in the cases of criminal trials, again, going back to the Hissène Habré is probably the best example of that. So I think that if people genuinely wish to see something being done, then they can actually do something about it. And that goes for anyone, really.
Thank you very much, Olga, for your optimism. Shall I give the floor to Levan? I think he wanted to ask a question, and maybe that will be the last question because it's 5:30.
It's rather not a question, but a comment to what Madame Brechtart mentioned. There is the light at the end of the tunnel because the ICC statute envisages a possibility to open an investigation upon prosecutors' own initiative, proprio motu. And a very good example of such an investigation is a Georgia case, which Russia would have vetoed absolutely if it would have been suggested at the UN Security Council, but the prosecutor has opened it nevertheless, Madame Bensouda. And also there is a Burundi case which was authorized proprio motu, and also the case of Côte d'Ivoire. Thank you. So maybe Syria next time.
Yes, sorry, just to respond on that. Yes, these are good examples, but in these cases, all of these cases, the court had jurisdiction on this. So, and this is not the case on Syria. So the prosecutor cannot open an investigation because Syria has not ratified the Rome Statute. And so the only way to go is through the UN Security Council.
Right, well, thank you very much. I think we could go on for a while, but I think it's time to call it a day, otherwise we're going to be zoomed out. I think that we can continue the discussion if we want at the bar on the beach. Shall I give the floor briefly to Jan to explain how this is done for those who want to join us, and then I'll come back to say goodbye.
Just briefly, I'm your virtual bartender today, and I'm taking you to the Hague Beach later this afternoon. I'll show you briefly how it works or talk you through. It would be helpful if Levan, for example, could put the PDF file into the chat again. The first thing I want you to do is to download that PDF file, because there is the link you need to access WonderMe. As soon as you leave Zoom, you won't have that file or the link. We're not going to Kumo Space, we're going to the beach in Scheveningen. So repeat after me. Het stoomschip scheert langs de Scheveningse kust. Try saying that after 2 or 3 beers. So basically you need a desktop PC or a laptop. Mobile devices do not work. And you have to leave Zoom to be able to use your camera and microphone, which WonderMe uses. Safari browser on Macs might not work. That's what I tried out. So first of all, I'll try to share my screen. It's all also in the PDF file. First of all, the website will ask you to give permission to share your microphone and camera. You click next, you'll see yourself in a small window, then you click next, take a photo, enter your name, and then you just are in the area where you see little squares, areas where you can bump into other people, literally. As soon as you bump into someone, the system will open and you will have a conversation with camera and sound. And as soon as you leave that circle again, you'll be out of that conversation. So the link is at the top of the PDF file. We'll also post it into the chat now. And if it doesn't work for you, just come back into Zoom and we'll help you to get into the WonderMe website. That's basically everything. Thank you.
Thank you very much, Jan. It really is very easy. I mean, I was able to figure out in 2 minutes. So if I can do it, everyone can do it. Of course, you know, you may have other things to do, but if you have time, please join us. And if not, I want to give a big thank you to all our speakers first, and for very insightful presentations, and for triggering, well, very lively discussions. And thank you also for your replies to the many questions. Thank you to the participants for your interest and for your support. To the interpreters, because I'm sure that at times it was not easy. We used some acronyms and things which maybe were not that straightforward to interpret. So please forgive us. And we're interpreters, so we feel for you. But I know that you did a great job. So kudos to you. And I also wish to thank very warmly the organizing committee. Veronica for her help on graphic design and many other things, social media, Claire, Annie, Jan, Zushra and Levan from the Bureau. It took a lot of work. It may not look like it, but it was a great learning experience for us. So I'm glad to see all the positive comments of people saying how much they've learned about the topic. And we've also learned on the topic and in terms of organizing this event. We look forward to seeing you at another meeting I don't know when that will be and whether it will be virtual or face-to-face. But in the meantime, we're going to work on the recording, and it will be made available in some form. I will let you know where and how. So again, thank you very much for your interest and for your time, and we hope to see you again soon. Bye. And now I'm going to wander me for a few drinks. Bye-bye.